once more. Just a quick one. Are the mooters for the day here? Both the petitioners and the respondents. Petitioners? Respondents?
Wait, are you petitioners or respondents?
Petitioners. Where are the respondents? Good morning once more. May I have your attention? Good morning. Yes, is the team in?
Mic check. Check mic, check. Kuna hiyo noise. Ni gani hizi? Ama ni mic check. Mic check. Mic check. Mic check. Sawa. Mic check. Mic check.
Check. Mic check.
Check mic. Check mic. Check mic. Mic check. Mic check. Mic check. Mic check. Mic check.
My Lord, Justice Oboto, Dr. Owino, senior colleagues, ladies and gentlemen, good morning. Good morning. Why are we not excited? It's a Saturday morning. Yes, ladies and gentlemen, we are coming in for the final rounds. This is our final stages of the Natural Justice Moot Court Competition on Environmental Law. We really thank the Lord Almighty for granting us this day to finalize this competition. Indeed, we were very grateful from what we saw yesterday. You exhibited a serious sense of participation in your research competition, in your research process, and even in your competition. We saw young enthusiasts, young practitioners who are enthusiasts on environmental law, which is quite commendable. For the finalists, we can't wait to see what you have for us. So before we begin, like yesterday and like any other day, we must have the host to at least welcome us in their home, right? So I'll invite Dr. Lando to welcome us in his institution, then we can proceed with our final stages of the competition. Welcome, Dr. Lando.
Thank you. Honorable Judge of the ELC, senior colleagues in the profession, valued partners, CMR, Natural Justice, my students, ladies and gentlemen, good morning, everyone. Yes, CMR are saying that we need to welcome them today and yesterday, but they are our friends and our partners, so huku ni nyumbani. So there is no need to welcome you again and again, so please feel very welcome, and all my students again, please feel very welcome to Riara, Riara University and Riara Law School. Our DVC was supposed to be here today, but she's held up in another engagement, so she sent her apologies. But she sent me the message of congratulations to all the participants, to congratulate you for having reached this far and for stepping up to, you know, participate in this very important competition that talks about pertinent issues on environmental justice and empowering communities to be able to engage on these issues that are current, and to just set yourself up for a career, tackling some of these difficult issues that have been tackled for the past 2 days. So without further ado, I just want to say thank you very much to our valued partners. Thank you so much to our students from other universities. We have, I think, about 14, 15 universities that responded to the call to participate. I really do appreciate you, and we don't take it for granted that we sent you an invite and you showed up. You know, not every day someone, it's not every day that someone shows up when you send them an invite, and so we take that very seriously, and we are very grateful that you responded to our call. And so without further ado, let me just welcome you once again to the finals of the second EJ Moot competition, which is being held in November 2023. And let me hand the mic back over to CMR so that they can take us through the program. Thank you so much.
Thank you, Learned Dean. Ladies and gentlemen, to head straight to our today's activity, we have today judges from different areas of practice, especially on environmental law. They have serious experience in this area of law, and just to introduce each one of them, I'll begin with Justice Edward Waboto. Justice Edward Waboto is a judge at the Environmental and Land Court. He's one of the youngest judges, actually appointed at the age of 38. You can imagine, at the age of 38, you are a judge of the High Court. We get great inspiration from what he has achieved, especially for us young lawyers, and even for you upcoming legal practitioners. You really need to get his contact to guide you, especially on matters of environmental law and even your future career if you inspire to become a judge. Other than that, Justice Waboto was part of the UNFCCC, United Nations Framework on Convention on Climate Change. He was part of the technical team that actually negotiated and even came up with the Paris Agreement. He was part of that Kenyan legal team. He has also served as a senior legal officer of NEMA. Other than that, Justice Oboto has provided great jurisprudence, inspiring jurisprudence on environmental law. So for the finalists, you need to convince him why you really need to win this moot. I challenge you to at least do more than enough of what you exhibited yesterday and even of what you've been researching on. Other than Justice Oboto, we have Dr. Omondi Owino. I must say Dr. Omondi Owino taught me professional ethics at Kenya School of Law, and part of my professional ethics that I practice, especially that the relationship between seniors and the young advocates is slowly but surely dwindling. And this is mostly attributed to lack of professional misconduct or professional misbehavior from young advocates. I must say no senior has ever complained of my conduct, at least for the short time I've practiced. So Dr. Mondi Owino taught me well, I must say that. He's also an enthusiast in environmental law. He's a consultant at MMK, and he's currently leading petitioners in the Baringo case, the famous Baringo case, for those who have done research and come across the case that is currently ongoing. So you also have a daunting task to explain to him or to convince him why he really needs to side with you today. Other than Dr. Mondi Owino, we have Clarice Wambua, who is a consultant at CDH on environmental law. He's also an expert in environmental law, and he has done quite a number of activities on matters environmental law. Besides her is Tali Israel Tali. Tali Israel Tali is a household name for those who mooted. He's done quite a number of moots. He's an advocate of the High Court of Kenya. He's currently the executive director at CMR Africa, and then he's also a consultant at his own consultancy firm. Seated far left is the famous Kimani Kimani. Kimani Kimani has an LLM from the University of Geneva on international humanitarian law. Kimani Kimani is a seasoned mooter. I lack a word to describe him on his achievements on moot court competitions. In fact, we used to participate in moot court competition knowing who the winner will be. So it was an exercise in futility, because sometimes you could just participate. It was good being in his team because you are assured of winning. But who unto you if you are on the other side? So he's done quite a lot on moot court competition, and from experience, the finalists, you really have to do a lot to persuade this bench. This is the bench that we have to you, and this is an opportunity that Natural Justice and CMR Africa is providing to you to first meet the judge. Before I became an advocate, I never had an opportunity as a young student or even a lawyer to greet a judge. I became an advocate, then shortly after is when I got an opportunity to come close to a judge. You students, you've been given a platform to at least meet the judge firsthand before you go to court. This is a tremendous opportunity for you to not only build your network, but also learn how to engage with your seniors, especially how to address a judge in real time before you go to Kenya School of Law and even before you become an advocate of the High Court. Please seize this opportunity and use it effectively. Like you were told yesterday, the legal profession is slowly but surely becoming an employment opportunity to like any other market that we have. It's no longer becoming a professional career, but it's becoming as though It's a source where people are taken in and taken out. So the competition out there is quite stiff, and you need to be apart from your colleagues on when it comes to certificates. You'll be asked other than LLB second class upper when you go to practice, when you go to seek for this opportunity. What else have you done? And if you have the natural justice certificate signed by the judiciary, signed by RIARA, University School of Law, signed by natural justice, you'll automatically be distinguished from your colleagues. So I challenge you to seize the opportunity, meet at least one senior that is around. We have advocates of the High Court who are available here. Take that opportunity, talk to them, get contact. You never know, they will influence your future. So ladies and gentlemen, without much ado, before we proceed to finals, we have the research category, where we have the best researcher who will take at least 10 minutes to take us through his paper, and he will at least convince us why he won that research category. So ladies and gentlemen, round of applause. Let's welcome Anthony to take us through his research on participation of women, pastoralist women in environmental law. Welcome, Anthony.
Honorable judges, members, before you is William Anthony Kanani. I will present a paper titled Okay, I'll start again for purposes of record. Honorable judges, members of the gallery, and distinguished guests present, good morning. Before you, this fortunate morning, is William Anthony Kanani, and I'll be making a presentation on my paper titled The Place and Power of Customary Law in Disempowering Women in Land Matters. I'll be taking 10 minutes of your time, and with your permission, I beg to proceed. Like caged animals, we are moving, but making no progress. It is 13 years now since the advent of the 2010 Constitution. Are we really making that progress? Land, Article 40, Article 27, talk about the Land Act Section 3.1, Section 5.1. All of them come to one conclusion, that land holds economic, social, and cultural significance in the lives of Kenyans and the larger world. Land has been described to be the epitome of the center, to be the epitome and the center of civilization. And in my paper, I'm arguing that customary law, as much as it falls below the hierarchy of laws in Kenya, it does hold a lot of significance. Customary law defines and permits. And I would like to quote Winfred Kamau, Patricia Kamote, Pauline Musangi, who all come to one conclusion that customary law, as much as we have these robust laws, it is customary law that still governs most rural communities in Kenya. Again, quoting the Merriam-Webster Dictionary and the Black Law Dictionary, they define customary law as the written or unwritten societal norms. Again, it's good to argue that customary law, as much as it has been argued to perpetuate, it does indeed empower women in land matters. I would like to bring to the attention of the judges and to the attention of the members vis-a-vis the article written by Winfred Kamau, in which she argues that most legal scholars in the past 2 decades have focused their attention on discussing on how customary law perpetuates. She objects by saying customary law, in which I concur in total, it does empower women in land matters. I'll be discussing the following in 3 glimpses. Number 1, customary law, as argued in my paper, does provide an avenue for public participation. In some communities, not all, but some communities, does provide a platform for women to engage in matters that are affecting them, hence providing an avenue for public participation. Again, customary law, one important factor, it does create an avenue for interdependence. Talk about the Agikuyu community, the pastoralist community. There are certain cash crops, as argued in my paper, which have been specifically been delineated to women. Women are recognized on the cash crops they are farming. So, we cannot totally override customary law because it plays a significant factor. Lastly, I would like, as argued in my paper, I would like to bring to the attention of the judges and members of the gallery that customary law, due to its flexibility, it's not static. We could say that we could argue it's progressive to some extent, meaning what was wrong 20 years ago cannot be definitely be wrong at the moment. So customary law, due to its nature, can change to prevailing conditions. And this brings to my argument in my conclusion, that instead of trying to override customary law and say that it only perpetuates, why don't we harmonize customary law? Why don't we legislate customary law to support the Constitution vis-a-vis Article 24, which provides that any law, including customary law, is only applicable up to the extent that is not repugnant to justice. Moving to my another key argument, I would like to bring to the attention of the judges that, of which most legal scholars would agree to, customary law does disempower. I will discuss that glimpse from, I'll discuss the key argument under 3 glimpses. Number 1, the patriarchal nature of customary law. Look at, I would like to give damning revelations in a report done by the Federation of Women Lawyers in Kenya. In their report, they noted that only 1%, women only hold 1% of title deeds. 5% of title deeds are held jointly by both women and men. Again, women provide 89% of the labor force in rural communities and even in large-scale farming activities. Again, 32% of women are heads of households in Kenya. So we cannot totally override the significance of women vis-a-vis customary law. The patriarchal nature of women tends to limit. You see, most people argue, and I quote, that women are meant to be seen and not to be heard. They are not property holders. I come from a community. I hold some ethnic resemblance to that community. And I could say, despite having 13 years, that it is still customary law, which is still in play. It is the major player that governs Kenyans. Again, customary law, there's deeply rooted cultural belief. And I would like to quote my idol and my mentor, the one, Chimamanda Ngozi Adichie. She posits, if culture does not make people, but culture makes people. If the full humanity of culture cannot accept women, then we can and must make it our culture. So again, it brings me to my point on empowerment of customary law, that the flexibility of nature, because it's us people who make culture. Talk about common law. Common law is customary. In essence, it's customary. So why don't we have legislated customary law in our statutes, but we don't want to legislate our own customary law in our statutes. So it's up to us to harmonize these laws and to create a nexus between the two and create a balance and see that customary law, instead of trying to override it in total, we bring it together and ensure that it supports the constitutional provisions. Remember, Article 259 provides that when interpreting the Constitution, it should be done in a holistic manner. And Article 24 clearly denotes that customary law is applicable in Kenya, together with Judicature Act Section 3, name them all. So it's not in contention that customary law is a source of law in Kenya. What is in contention is Where do we find the balance? Where do we strike the balance? So as I conclude, I want to invite the members of the bench and the members of the gallery that instead of trying to override customary law, why don't we create an harmony? If there are no further questions, I beg to rest my case. Thank you.
Wow. Where do we strike the balance? My lord, perhaps we can have insights, maybe to guide this learned researcher. This will be a lecturer soon, or maybe just guide his thoughts based on his research, and even any suggestions to guide his further research. So you can have from that side to this side.
Thank you very much for the opportunity. I had an opportunity to listen to the researcher present, and not just at this moment, but during the presentation in itself. And I genuinely thought that the research paper was properly argued, in that it did not, as instinctively as others would have, it focused on the negative impacts, on the disempowering of customary law, but also looked at how customary law can be harnessed in order to address modern challenges. So just as a pointer, I think the paper itself and the content was excellent, but just it would be a pointer on just the presentation in itself, in a manner that you keep the audience engaged and interested in listening to the topic, because it's usually said that many people talk about very complex and important things, but people never pay attention to them because of how they present them. So like climate change has been something that has been spoken about a lot for a long time, but people never really paid attention to it because of how it was being explained by the scientists on television and all that. So just focus on breaking down your paper and presenting it, breaking it down a little bit even more, so that the audience that is listening to you has one or two things that they can take away from the presentation without even having read the entire paper. Just one or two important things that they can take out from the paper and run with it. But excellently done. Thank you.
Thank you. I think it's a good presentation. It's nice listening to the presentation and to see the research that has gone into it. Going forward, I think the researcher might want to look at the live practical challenges happening today and the conversations that surround customary law and its future presently. Just one instance that comes to mind, for instance, might not be related to this conversation on climate change, but the application of customary law, for instance, in burial disputes, as we have understood it and as we know the SM Otieno case and how it played out vis-a-vis the recent decision we had from Kisii on the same. So when you look at it and live issues that people are talking about in the society, then your paper will also get that attention to push the conversation forward. Otherwise, I wish you all the best, and I encourage all of us to invest in deep research. Thank you.
All right, thank you to the presenter. That was a really illuminating presentation. I quite enjoyed learning about the empowering aspects of customary law. I knew about the disempowering aspects, but it was nice to hear the other side of the coin. I think your presentation is what is called to be continued. You know, when they have TV programs and they put the dots, to be continued. And how I think you could go forward with this in your paper would be maybe in the conclusion to map out what further areas of research arise from what you have found. So for example, you could look at what facets of customary law in Kenya have managed to strike a balance. Customary law has different elements. So is there a particular case study of the balance you're seeking? Is it possible? Is there something in Kenya that shows it's possible? And then you could also widen your scope and check whether there's a jurisdiction outside Kenya that offers a study of how this balance between the empowering and disempowering aspects of customary law can be achieved. But I look forward to reading the sequel of that. Thank you.
Thank you so much, the young researcher. I think in my view you have done well. You are able to bring out the true picture and the issues. Perhaps some points for take home and further consideration to incorporate. If I can just pick with what my colleague has mentioned, we would have expected also to hear more from how in Kenya practically the courts have been able to give life to the provisions that you referred to, the provisions of the Constitution, because you mentioned to them, and you took stock and said it is about 13 years since we had our current Constitution. So it was also important just to make reference to the specific cases, and there are a number of cases where the courts have tried to give life to that particular provision and trying to address the conflicting customs or practices or issues that have hindered access to justice and women in particular. And then I think it will have also been important, because this is a research you are doing, you try and give analogy for this particular country before 2010, where we were, and in terms of the jurisprudence that were developed by then. For those who have studied the historical aspects of the legal profession in Kenya, and of course our judicial institutional interpretation of this, you'll note that previously we had judges who are from a particular jurisdiction rather in the Commonwealth. So when they came to Kenya to adjudicate those disputes, they didn't have the true picture of our cultural settings and how we relate. You can call them the foreign judges or the Wazungu judges. But now we have judges who live in a society. They are versed to what is happening, and also they are aware. And of course, they have tried to breathe life to the Constitution and balancing those particular provisions of the law. So for me, this will have been a better aspect to incorporate and to consider for future. But generally, it has brought out the real issues and what I was expecting to hear. Thank you.
Yeah, thank you to the researcher for delving into this long-drawn discussion. And I say long-drawn because it falls within the ambit of what we would describe as legal pluralism. How do you reconcile competing bases of law? And of course, we cannot know how far we go without looking how far back we have come. And if you were to trace the history of the Judicature Act, Cap 8 laws of Kenya, then you would understand why we have Section 3, which provides for qualifications on application of customary law. And I think the Constitution amplifies Section 3 at Article 159.3 on traditional dispute resolution mechanisms. So one of the things I would encourage you to look at, one, are perhaps two writings. We have a journal article by Eugene Cotran, who is a fabled expert in this area. But there is another one by Professor Ambani of Kabarak University on the same topic. And my quest would be, I would have liked to hear specific situations as the judge has challenged you on how then the courts have interpreted the provisions of the Constitution. Because if you look at the Constitution, it accommodates customary law in a very significant way, but it also tries to reconcile the tension that is inherent between what we would call common law and customary law in a number of ways, Article 159 being one of them, Article 2.4 being another, where it is expressly acknowledged as a source of law in that very high hierarchy of our laws. But apart from viewing customary or the African society as being largely patriarchal, we also know that there are matrilineal communities. So whereas then it could have areas of disempowerment, it could also have areas where then it empowers individuals to resolve conflicts without necessarily clogging the machinery of the judiciary. Yours is a good addition to the voices that have been concerned about the inherent tension between these two sources, and you will realize that at the early stages of the development of our legal system, there were native African courts which were kept purely for the natives, and qualified advocates were not allowed to practice in those courts. And the reason why we had customary law was not because the colonialist was very philanthropic, but he thought that to govern this group of people, he needed to subject them to a law that they understood. And these laws have refused to go away. So I agree with you that they are part and parcel of our DNA, and as such, we need to uphold them, of course, subject to the strictures of the Constitution and the Judicature Act. But otherwise, I think your research bears significant promise, and it will be glad to read your output incorporating the proposals made. Thank you.
Thank you, my lord, for the feedback. Thank you, Daktari. Of course, any day listening to you, it's always a learning moment. And my wish is one day I should make truth the sage, an apple does not fall far from the truth. Being your student, there's a lot to learn and there's a lot to admire from you. For the rest of the judges, we're really grateful for your comments, and we hope that the young researcher should make true the comments made and publish your paper. Ladies and gentlemen, this is how you've been waiting, the final rounds. I invite the petitioners and the respondent to come forward and take their seats. You will have 45 minutes each to argue your cases. You will advise the bench how you'll utilize those minutes. And then as a ground rule, we request that you have your phones on silent mode. You also avoid movements, considering that we are streaming live the event and will not need much interruption with the cameras. The petitioners and the respondents, please move forward.
But I don't want to give them, because you would. It works.
Let me just raise it. Just a minute. Mr. Odhiambo, just a minute.
One, two.
ELC petition number X of 2023. The petitioners Mzee Juma Ali, Pastoralist Association of Hazina versus the respondent, Ministry of Environmental and Natural Resources, National Environmental Management Authority, and the County Government of Rudolph. I believe all parties are familiar with the facts of the case. Maintain silence in the courts. May proceed.
Sorry, just some few guiding directions to guide the participants. Welcome to this particular court session once again. The session is being presided by Justice Edward Waboto, yours truly, and then with my colleagues who are also present. And for the benefit of the participants, I'll request them to introduce themselves so that we can allow them to proceed. So I'll start with my extreme right. Thank you.
Good morning. My name is Derek Kimani. It's a pleasure to be here.
Good morning. My name is Tali Israel Tali. It's a pleasure to be here.
Good morning. My name is Clarice Wambua.
Thank you so much. At least you know the judges that are appearing before. So to our participants, you can start and you'll strictly observe time in this particular courtroom. Thank you. You can proceed.
Greetings, Honorable Justices. I echo the words of Ngugi wa Thiong'o in his book, The Wizard of the Crow, where he stated that you can never ask a father his favorite of his child. Honorable Justices, the applicants, the government has decided to choose the favorite of his children and the worst of his children, of which the fact is proved to be our client. Honorable Justices, my name is Sarah Theuri. I am the lead counsel, appearing on behalf of the petitioners, accompanied by my co-counsel, Vincent Gurema. And the time gallantly allocated to us, I will use the first 23 minutes to tackle the first and the second issue. My co-counsel will use the next 20 minutes to tackle the third, fourth issue, and also the prayers. We reserve 3 minutes for rebuttals. Honorable Justices, The first issue is a contextual question of whether the rights of the Ramila community, the right to self-determination, free, prior and informed consent, and public participation was upheld. I'll discuss this issue in 3 limbs, that is the right to self-determination, free, prior and informed consent, and public participation. And in the first limb, the right to self-determination, the applicant submits that this right was violated by the respondents pursuant to Article 10.2 of the Constitution, where it says that public participation is a principle and value that is binding to all state organs. Also, in Article 60D of the Constitution, states that transparency is one of the principles of land policies. Article 20 of the African Charter gives the indigenous communities the absolute right of self-determination, and in self-determination they have the self-determination to political status, social and economic development. The first and the second respondents...
Council, just to clarify so that we're clear before you proceed, the right to self-determination you allege has been violated is under which article of the Constitution?
Honorable Justices, there is no absolute article articulated in our Constitution of right to self-determination. However, right to self-determination is seen in public participation that is enshrined in our Constitution pursuant to Article 1 of the Constitution that gives the sovereign power to the people.
So which article has been violated? Because in light of Anarita Karemi and Muo Matemu decisions, we are supposed to be clear on what right has been violated. Perhaps you could guide us on which article has been violated, which right has been violated under the Constitution.
The right of self-determination. And this right of self-determination is under Article 20 of the African Charter. The right to self-determination gives the people the political, to determine political status, social and economic development. The social and economic development, the people should have their say, and this right to self-determination forms part of public participation. That's why the applicants submit that this right was violated by the respondents. Moving on to my second limb of free, prior and informed consent. The Enderrice case entails to us that in free, the consent must be given without manipulation, coercion or intimidation. Honorable Justices, the respondents try to manipulate our applicants pursuant to paragraph 17 and 19 of the fact sheet when they told them that we are going to fast track the registration when you agree with this project. But later on in paragraph 26, we can clearly see that the government was unwilling to fast track the registration of the community land. This is a proof that the government manipulated the people to accept this project because they knew that the registration they tried to register their land. However, their land was not able to be registered fully because of hampered factors pursuant to paragraph 6 of the fact sheet. And informed this free, prior and informed consent. In informed, it said that section 36(2) of the Community Land Act says that the people should be informed, and in any project that is to be stipulated in the land, 2/3 of the adults should be involved and should accept this project. However, we can see, pursuant to paragraph 19 of the fact sheet, only few CBOs were informed, and they also were involved in the Solio agreement. In here, the fact sheet says that the Ramila community form part of the most largest people in the community, and the few CBOs do not form part of the 2/3 of the adults of the Ramila community. And in consent, we can see that in consent, the people should give their consent. Honorable Justices, the people never gave their consent to this project because they never knew about the project. The only people who knew about the project were the 12 elders and chiefs and the few CBOs who were informed about the project. The other people came to know about this project later on, where the people started to have problems not able to go to the conservative areas. Moving on to my third limb on public participation. And in public participation, the elements of public participation are entailed or enshrined in the case of Muikol Basin, local community, and 15 others versus the permanent minister of energy versus 17 others.
Sorry to distort your flow. Still again, now on the right to free and informed consent, is it also a standalone right? Is there a standalone right to free and informed prior consent?
Honorable Justices, the free, prior and informed consent is not a standard right. However, it is a standard right under public participation because the people have to be informed about this information. The people have to be given time to make comments about the project that they were given. The people have to freely give their comments.
So, Council, what then is the essence of you having the right to self-determination, the right to free, prior and informed consent, and the right to participate in decision making? Wouldn't you have just said the right of the people to participate? And just as asked by co-judge, is there no expression whatsoever in relation specifically to indigenous people of a standalone right that is known as the right to free, prior and informed consent?
Honorable Justices, I'd like to answer your question with Section 18 of the Foreign Judgment Act, where it states that any judgment, cases, or statutes of international law can be used in any court of any Kenyan court. And in here, we have used the right to self-determination under the African Charter, the right to free, prior and informed consent in the case of the Endores case.
What is the purpose of that act that you just cited?
Pardon?
What is the purpose of that act that you just cited?
The Foreign
Yes.
Judgment Act.
Yes.
The purpose of the act the purpose of that act mostly is to ensure that the people, the international laws and international judgments can use some of the judgments that were used. However, it will use it persuasively,
Council,
not
just
binding.
take time. What is the purpose of that act?
I stand guided.
Proceed.
Sorry, let me protect you as the presiding judge. I'll allow you to finish. I'll allow you to finish because we are interrupting your thought, your flow of thought, and also eating into your time. And then my colleagues can raise issues after your presentation. So you can proceed. Thank you.
Much obliged. Thank you. The elements of public participation, the first element is that the government should form a fashionable program for public participation, and in forming the fashionable program, it should establish the quantity and the quality of public participation. The government formed a fashionable program. However, the fashionable program never entailed the quality and quantity of the public participation. We can see this pursuant to paragraph 19 and 20 of the fact sheet, as where only few CBOs were informed about the Solio agreement, and only 12 elders and chiefs from the Rudolph community were informed about the project, and they were given the study to criticize and make comments about it. The second element of public participation is that the court will not use any litmus test to define public participation. However, the test that will be used is the test for effectiveness. Honorable Justices, there was no effective public participation pursuant to paragraph 19 and 20, where only few CBOs and 12 elders and chiefs were involved. And in section 36(2) of the Community Land Act states that 2/3 of the adults' views will be viewed. In here, the few CBOs, 12 elders and chiefs do not form 2/3 of the adults, Your Honor, my lords and lady. The third element is that the people should have access to dissemination of information. And in Regulation 17 of the EIA Act, EIA Audit Regulation, it states that the notice should be written in both local and formal official languages. In here, we have seen that the report was written in official language because in paragraph 20 of the fact sheet, the government's Professor Ujanja stated that he was unable to popularize the project because of the linguistic barrier, thus not able to upheld the Regulation 17 of the EIA Act. And in the case of Mohammed Ali Badi and others versus Attorney General, in this case states that in any environmental issues of public participation, what will be relied on is that the statutory provisions should be upheld. And if it's not upheld, then the public participation will be made null and void. In here, the government never went the government went against the Regulation 17 of the EIA Act, because Regulation 17 also states that in public participation, the government will also post posters, will state the news, will say about the project in the radios, both in formal and informal languages for 2 consecutive weeks, will give the report to the people within 2 consecutive weeks, and also will hold at least 3 public meetings. We can see that in this was not upheld, and thus they never followed the statutory provision under Regulation 17 of the EIA Act. The 5th element is that not everyone individual's views will be taken into account. However, the government will act in the good faith of the people. The government never acted in good faith of the people. As you can see, pursuant to paragraph 26, they promised the people in paragraph 17 and 19 to fast track the registration of the community land. However, they were unwilling to fast track this registration of the community land pursuant to paragraph 26. And in the last and the 6th element of public participation is that the role of public participation is not to uphold the democratic role of public officials. However, it will enshrine the views of those most affected. The views of those most affected were not enshrined because in the first place, the people never knew about the project, and thus their views were not enshrined. Moving on to my second issue on whether the project was a way of conserving and protecting the environment. Section 54.2 of the MCA Act, it dictates that in involving any project, it should be done without prejudice. Prejudice here means that the people's right should not be violated. It's clearly stated from the fact sheet that the people's rights were violated. The right to life of the people, pursuant to Article 26 of the Constitution, was violated. And you can see that in paragraph 28 of the fact sheet, where 2 people were killed by the local police sent by the government when they wanted to peacefully protest. The right to hold peaceful demonstration and articulated under Article 37 of the Constitution was violated because in paragraph 28, the government sent local police so that the people could not hold peaceful demonstrations. The people held peaceful demonstrations by singing traditional songs. And the government went on being embarrassed by people peacefully demonstrating. They sent local police and to ensure that the people do not demonstrate. And I'd like this court to be guided also by section 51E of the MCA Act, where it stated that you can never plant an alien or a foreign species in an ecosystem. The government planted foreign species and alien species pursuant to Article 22 of the fact sheet. They went on ahead to plant eucalyptus tree. Eucalyptus tree is known to be a thirst tree. And in the case of Lyford Gishari Leonard versus Wero Tree Factory, the court held that the cutting of the eucalyptus tree was well done by the applicants in that case because eucalyptus tree was known to absorb all the nutrients of the soil in areas that have farming activities. Honorable Justices, the ECRM project, pursuant to paragraph 14 of the fact sheet, one of the aims was that they wanted to introduce farming activities. Why then will they plant eucalyptus tree? And they knew very well that the eucalyptus tree will absorb the nutrients from the soil. And from that, the applicants also never conducted a climate change impact assessment to the environment, violating Article 20 of the Climate Change Act of 2016 and also 2023. The reason why I've stated the 2 articles is because this project was implemented in 2017, thus they used the 2016. However, it's the same that applies to the 2023. And in this, we can see that the government implemented this ECRN project act so that they could not protect but rather benefit from the project. And in the case of Ken Kasinga versus Daniel Kiplangat Kirui and 5 others, it says that in this case, where a procedure from the protection of the environment is provided by the law is not upheld, this will be assumed by the court that the project will cause harm to the environment. With that, I'd like to take questions from the Honorable Justice.
So we'll start with Justice Kimani. If you have any questions to the oralist.
None from me.
Thank you. Maybe just one or two. On planting of eucalyptus trees, you've said that they will absorb nutrients from the soil.
Yes.
And that is not contested. However, we are told that this land is not used for agriculture. It is used for a pastoralist. So how does that affect the land which is not used for agriculture?
Much obliged, my lord. In paragraph 14 of the fact sheet, the government states that in the project, the ECRM project, one of the ways is that they will introduce farming to the people. Why would they want to introduce farming and yet they plant eucalyptus tree, and this eucalyptus tree is known for absorbing nutrients to the soil, and when the plants are planted where eucalyptus tree is, they won't be able to grow and nourish properly?
I don't know if we're getting each other correctly. At paragraph 2, it is said that this land is arid and semi-arid land. The land is not used for crop production. In fact, crops cannot be planted. That is why it's used by pastoralists. So how does absorption of nutrients from the ground affect the way of life of the people?
Much obliged, my lord. The planting of eucalyptus tree affects the way of land of the people where the ECRN project was introduced. The ECRN project introduced, it is stated in paragraph 4 that they will introduce modern methods of farming. And why will you then introduce farming in a place of pastoralists and then you plant eucalyptus tree?
All right, Council, I've listened to you very carefully. I've also listened to the responses that you have given to my co-judges. And I put it to you that the reason you're struggling to assert the right to self-determination, the reason you're struggling with free, prior, and informed consent is because you have not engaged with the international law regime. Your submissions have relied on local law, which is good, well and good. You have alluded to the African Charter. I would like you to tell us beyond, because your country is a member of the international body of countries, what international law would you use to convince us that your right to self-determination, your right to free, prior, and informed consent has been affected? And why does it apply to your case?
Much obliged. Article 3 of the UN Declaration of Rights of Indigenous People also states the right to self-determination of the indigenous people, and it's almost the same as Article 2 of the African Charter. And in this it says that the people are freely given, it's an absolute right. The indigenous people are freely given the right to self-determination to determine their political rights and their social and economic development. The self-determination here is mostly measured on the social and economic development. The ECRM project's aim was to develop the ASAL areas, and this was done. I've answered the question.
That you've answered in terms of the international regime partially. I would also like to draw your attention to the International Covenant on Civil and Political Rights. Does it have any application to your case? And the declaration you have mentioned, is it a treaty? Is it a source of international law? Are UN General Assembly resolutions international law? Can we rely on them in this court?
Much obliged. We can rely with the UN declaration because Article 2.6 and 2.5 of our Constitution, it says that international treaties and international laws form part of the laws of Kenya.
That is well and good. I'll let it pass. You've answered partially, but not fully. I'll move to your second submission. Article 69(2) of the Constitution of your country says that every person has a duty to cooperate with the state organs to protect and conserve the environment. Is your community doing what they should do under this provision of the Constitution? Your submission did not justify vis-a-vis the state responsibility to conserve the environment and the action they took. Have you convinced us that you're not a foul of this provision of the Constitution?
Much to oblige. In section 59 of the MCA Act, it states that in any project that you will want to put in our land, you should involve the people. And in here, we can see that people were not fully involved, because also in the same section and the same act says that involving the people, you need to post posters, you need to advertise it in
Council,
radios.
may I interrupt you? You have quoted MCA, that is a statute. I have quoted Article 69(2) of the Constitution. Which is the Grundnorm?
The Constitution.
All right. So which has precedence?
The Constitution.
All right. I let my co-judges proceed.
I'd like to answer your question in a better way. And in here, the Constitution states that the people have a right also to help the government in conserving the environment. And in that section, it says that in any project, the people must be involved in making decisions about in accepting the project. When they do not, in accepting the project, it's a way of helping the government to know about. Because also in the elements of public participation, according to the Moot Basin local community, the people's views are important. The people's views will determine if the project will go on. And in here, the people may give advices, may also give their views, but this project will not go on because it has more negative effects that you have stated more than the positive effects, and thus enshrining the Constitution of Kenya and also the MCA Act.
All right. Thank you, Council.
Yeah, thank you, Council, for your very spirited submissions. My first question would be, does your country have an EIA Act? You have referred us severally to an Environmental Impact Assessment Act, and we would want to know which one it is. But also on the second limb of my question, you have referred us to the Moot Basin case as your basis for testing effective public participation. Would you be kind enough to supply the bench with what would be a leading authority in your country on public participation? Thank you.
Much obliged. The needy authority is the Moot Basin. The EIA Act is a way of giving boosts to the Moot Basin case.
I think I would encourage you to listen to the question before you attempt to answer it.
Okay.
Does your country have an EIA Act?
Oh, much obliged. I would like to retract my statement. The EIA is not an EIA Act. It's the EIA regulations on it.
Made under which act?
It's made under the Environmental Management Coordination Act.
Okay. And what is the leading case in your country on public participation, generally, not only restricting the consideration to environmental matters?
Pardon your question?
What would be the leading case on public participation? What amounts to effective public participation?
Both forms part of the need of public participation. The Moot Basin gives us the
I'm
elements.
asking for a locus classicus. What is the locus classicus in public participation?
I will subject that question to be answered by my co-counsel in submission.
Okay, you think about it.
Thank you, Councillor Theory. I think my colleague justices have asked you questions which I would have asked earlier. I only have one question for you. Since you are the lead counsel of your team and you have presented this petition to us, so assuming you are to retire to write our decision, I didn't see you refer us to any reports by whatever nature, either from experts in particular field, or it could be experts by knowledge or even indigenous knowledge on how this particular community will be affected. Because remember, you're presenting this petition for us for our consideration. So probably could you point that to us on where you can get that particular information before we retire to consider that particular petition?
Much obliged.
Thank you.
I'll subject my report on the second issue, and Ken Free stated a report in 2010 about facts of growing and use of eucalyptus in Kenya, and he stated that in paragraph 15.
Where is that in your petition?
Pardon?
Where is that information in your petition?
Information in my petition. It's
Yes.
a report that Ken Free
Yeah,
submitted.
where is that reference?
In paragraph 22. It's a reference of paragraph 22, where the government planted eucalyptus tree. And in that report, we are starting to state the negative reasons as to why eucalyptus tree should not be planted in an area.
Myself from giving the defense some pointers, but it's still not a report as such. But anyway, you can proceed. We'll take that for now. Thank you.
Thank you for your questions. And since that my time has been well spent, I'll cede floor to my co-counsel.
President Judge, my lady, my lords.
You'll wait for us to give the go-ahead to start.
I stand guided.
So you are ready to, I think we are ready. You can proceed. Thank you.
President Judge, my lady, my lords. I detest the Roman philosophers for their cheekiness, but I find meaning in the words of Marcus Antonius Aurelius in his book, Meditations of Marcus Antonius Aurelius. He states that he is not fooled who knows himself to be fooled. Honorable Justices, the conundrum that is vexed under issue number 3 is as to whether the license should be cancelled for lack of proper EACIA regulations, environmental social impact assessment, regulation, report and study. Honorable Justices, the applicants backed by law and facts aver to this honorable court that it will be justifiable to revoke the license. This argument is fronted by Section 58 of the Environmental Management Coordination Act and in tandem with Section 58, 59, inter alia being Section 23 of the EIA regulations. Honorable Justices, Section 58 of the MCA Act provide that the second respondent herein being NEMA are supposed to be informed, are supposed to issue the license after verifying the contents of the ECI regulations. Failure to that is a breach of process. Honorable Justices, the issuance of the license is pursuant to Section 63 of the MCA Act. And in this, the respondent, the second respondent was supposed to issue that license only after verifying and being convinced beyond reasonable doubt that the project was good for the environment. If the research was not done with due process, then there was no need, there is no legal basis and validity to issue the license. Honorable Justices, on matters of process, I will seek reliance on Raila Odinga case versus IEBC and 20 others And in this, Emeritus Chief Justice David Maraga stated that the elections were challenged due to failure to follow process. Due process can be a ground for revocation of the license. Honorable Justice, Section 23 of the EA regulations set grounds for revocation of our license, and amongst them is that if the project contravenes the set out conditions, 2 being if the project is modified, and 3 being if the project poses an environmental threat. On ground number 1, on modification, this project was modified. There was closure of migratory routes, there was closure of religious sites, and it contravened the Solio agreement. Honorable Justice, list the bench has further questions. I wish to proceed.
Sorry, what did you say? Your last sentiments, I didn't get you on that. You are too fast.
On the Raila Odinga case?
No, have you said you have concluded? I didn't get your last sentiment.
That if the bench has no further questions, I wish to proceed to issue number 4.
Proceed.
Honorable Justices, the 6th king of Babylon, Hammurabi, in his book, The Code of Hammurabi, states that an eye for an eye, that is what humans deem as justice. The eye we seek from the government is compensation. Honorable Justices, on this we are fronted by Article 40 of the Constitution, which states that upon acquisition of land, there should be prompt payment. Section 37 of the Land Act dictates that community land should be manned by the enactments of Section 63 of the Constitution, which again echo the words of Article 40 that states that there should be prompt payment upon acquisition of such land. The community is supposed to be the sole beneficiary, and in this case, my lord, the term is that they are supposed to be the sole beneficiary of any acquisition or any investment in their land. This was not done by the respondents. We seek reliance on the Enrois and Ogek case, where the court awarded pecuniary and non-pecuniary to the communities herein being Enrois and Ogek for use and vexation of their lands. Honorable Justices, Section 23 of the Community Land Act again provides for compensation of use of community land. I would like to proceed to answer the question noted by my lord that was forwarded to me by co-counsel.
Other issues?
No, I'm not done with that, but I want to handle that.
Just proceed with the other issues, then we'll come back to that.
My lord, on the criteria for compensation, pursuant to the fact sheet, there was a sale of 6.8 carbon offsets. The sale of those 6.8 carbon offsets, in the market value at that time, the 6.1 carbon offset, the market value was in between $40 to $80. At that time, a dollar trading against the Kenyan shilling was at 113. If we do the mathematics, 113 times 80, in assumption that the government sold to the highest bidder, will give us around 61.2 billion. We seek 70% of that amount, that will be given 42 billion, because the government invested only in building three schools and 2 boreholes. 3 schools, a school, as per the words of Professor Magoha, then Minister for Education, said that a classroom costs around 1.2 million. Hypothetically speaking, if they were to construct 3 classes, a school is supposed to have around 24 classrooms. If we do the math, that comes to around 100 million. Construction of boreholes per meter is around 10,000 Kenyan shillings. If we do the math, that also comes to around 50 million. The government gave us not even the tail, but the first of the tail. Honorable Justices, William Shakespeare, in his most famous sonnets, sonnet number 77, states that the world is a stage and every man has his time of exit and his time of entrances. In my entrances, my lords and ladies, I came lamenting of the tribulations caused upon us by the respondent. And in my exit, I pray that when the court retires for determination, we pray that a ruling be made that the respondent violated the right to self-determination, the applicants did not consent to the use of their land, and that the court declares no sufficient public participation. We also seek revocation of the license of practice of Professor Ujanja, an agent of the second respondent. This is pursuant to regulations of the EIA regulations 13, and that any any other relief the court grants as it may deem fit. My Lord, I would like to answer the question fronted to me.
So you can proceed.
On matters of public participation, our jurismetics and jurisprudence do not clearly voice themselves. However, in the Kesavanda Kerala case, which guided the BBI case, there is an issue, a holy grail in the Constitution about the people being consulted. That the people are the sovereign, that they have to be consulted. In the Kesavanda Kerala case, the issue was that some provisions of the Constitution and some articles and some processes cannot be done without the people consenting and without the people being informed. The reason as to why the BBI was cancelled was because of failure of that aspect of consulting the people. And in the Kesavanda Kerala case, again, the same is being voiced, that failure to consult the people while executing some provisions of the Constitution cannot be entertained. Therefore, the court cannot be asked in guise to come and upheld the submissions of the respondents. Honorable Justice, list the bench for the questions. I wish to cede floor.
We'll now take questions from the justices. We start with Justice Kimani.
Counsel, putting your words back to you, you said that the license can only be issued by NEMA if it is convinced beyond reasonable doubt that the project will be beneficial to the community. What is your authority for this assertion? And if any, does the project not have benefits which can be seen, including the ones you have cited, the building of schools? Further, a second question. You have stated that the limitation of access to cultural rights, cultural sites, traditional migratory routes, and water holes in the conservation areas constitutes modification. Is that the, what is the meaning of modification under the regulations, and does that constitute modification? And lastly, if I got your answer to co-judge's question, is it your assertion that there is no locus classicus with respect to public participation in the state of Hazina? That you had to go to India and rely on the Kesavananda decision?
Much obliged. On the issue of modification, I seek reliance on Section 58, inter alia being 59 of MCA Act. And herein, apart from modification, there is the aspect that if the project proves to be detrimental in the future years, because the ECIA project, the ECIA regulations declare that this is a continuum process, that the environmental should be audited timely. And if the fact sheet is anything to go by, the tribulations of the Ramila people began after the inception of the ECRN project.
Well, I understand the modification is from Section 58. How is that interpreted? And does this locking out of the people from the conservancies amount to modification as per the interpretation? And just give us an authority that interprets that particular section. Can proceed to answer the other questions. Yeah.
Okay. On the issue of the Kesavananda and the Indian case I've cited, the BBI was informed in his submissions to the Supreme Court Senior Counsel Learned Professor Kaminwa used that case to persuade the court.
I understand the BBI, but we are speaking specifically about licenses issued by NEMA, all right?
Yes.
There is a plethora, and the co-judge from the ELC will tell us that there is a plethora of jurisprudence emanating from the ELC and the National Environmental Tribunal that speaks specifically to public participation and environmental impact assessment. So that was the question posed by Judge. So is it your assertion that there is none, that we should go back to India?
that the people are the sovereign, that sovereignty emanates from them. And if that is anything to go by, withdraw authority from the people. We have to consult the people. It is a government for the people, by the people.
Thank you. 2 or 3 questions from me. On issue 3, it's a jurisdictional question. As I understand issue 3, you want the license to be cancelled.
That is our assertion.
Section 129 of the MCA Act says, if anyone wants a license to be cancelled, they should first approach the National Environmental Tribunal. So, do you think this is the proper forum, or the proper forum should be the net?
My Lord, that question is intertwined with the issue of the doctrine of exhaustion. And in that, Section 13 of the Environmental and Land Act states that in the interest of justice, the court may take into account, in the interest of justice, and take into the scope of the public interest, that, and Section 9(4) of the Administrative Action Act, the Fair Administrative Act provides that exceptional circumstances granting this court the jurisdiction to entertain the matter beforehand in the interest of justice.
There is a 3-tier criteria where you are exempted from exhausting remedies. If they are unavailable, if they are ineffective, or if they are insufficient. The remedy in question here, and that is the legal test, the remedy in question here is the net tribunal. So is it your submission that the net tribunal is unavailable, ineffective, and insufficient?
My Lord, in our jurisprudence, it is yet to be put into practice, but there is a...
Really? It's okay, thank you. The next question, on issue 3, on issue 4, on compensation. Is this a case of compulsory acquisition under the Land Act, or is this a case of surrender under the Community Land Act?
My Lord, I will not like to be tied with your grammar, but I will use your grammar again and say this is a case of manipulated surrender.
No, these are legal terms. These are not linguistic terms. Compulsory acquisition is a process, it's a legal process done by the NLC, right? So I want you to take one approach. Are you saying it is compulsory acquisition or surrender? And the reason I say this is because if you say it is surrender, there is no compensation for surrender. If you say it is compulsory acquisition, and then we can examine that submission. So which side are you picking?
Compulsory acquisition.
Thank you. Now, if it's compulsory acquisition, we have the Land Acquisition Tribunal, which is supposed to listen to grievances of compulsory acquisition of land. After you approach the Land Acquisition Tribunal, that is when you come before this court as an appellate mechanism. Did you approach the Land Acquisition Tribunal?
My Lord, the formation of this court, pursuant to 165, gives it original jurisdiction to entertain both civil and criminal matters in original capacity. The only limitations are matters reserved under 165(2), and that being election matters. We assert that the court still has jurisdiction and it can entertain the matters beforehand. Yes.
Okay, very well. Finally, even assuming we agree with you and we are to compensate you and the community, the land in question is unregistered land. So who should we compensate?
The provisions of law under 40 provide that unregistered land is supposed to be held on the behest of the community by the county governments. If the county governments are to be compensated, then it trickles down unto the people. However, the malicious character of the current county government, we seek that the court directs that these monies be directed to the CBOs. It is our prayer.
The CBOs that you complain, they participated in public participation. It's okay, thank you. Thank you.
Very much obliged.
Thank you for your submissions, Council. I'll just pick up from where my co-judges left off. We note that the basis of your claim is that your land has been compulsorily acquired. But from your submissions, you entered into the Solio Agreement in 2017. And by virtue of this agreement, you agreed to the project, to the setup of conservancies, and importantly, you have a dispute resolution clause in the Solio Agreement that states that alternative dispute resolution or alternative justice systems will be used to determine any disputes that arise on the management of the land. Have you pursued the ADR measures that have been set out in the agreement you freely entered into?
Lady Justice, on the question of pursuing the ADR methods, on our first attempt, we were met by resistance from the police officers.
Where do you assert that? That seems to be a new allegation. When the police officers engaged with you, was it while you were pursuing ADR? Or was that a protest? Is a protest an ADR mechanism?
No, the community raised concerns.
In what way? How did you pursue ADR measures?
We assert that we have not yet pursued that ADR method. However, that does not limit the court to entertain the matter at hand.
And what do you base your claim on, that you can bypass the provisions of a legally binding contract?
The Fair Action Administrative Act and Section 13 of the Environmental and Land Court Act.
What does the Fair and Administration Act provide?
Exemptional circumstances granting the court jurisdiction to entertain the matter beforehand in the interest of justice.
Okay. It would be important that you make that submission up front as opposed to waiting for questioning, so that we are fully aware of why you're here and not pursuing mediation or arbitration. And it would be important to tell us which exemptional circumstances are these that necessitate us to hear this matter and ignore your contract.
In the interest of public justice, in the interest of justice and the public.
In what way? I note that you have already received a share of the carbon credits. You have enjoyed the fruits of the project. You have had schools built from the carbon revenue. What public justice is missing?
My lady, the investments herein compared to what the government acquired after the sale do not, compared to the value of the sale that they got, do not amount to a mere 30%. And the law states that the community is supposed to be the sole beneficiary of this.
The sole or equitable benefit sharing?
I stand guided, equitable.
Thank you.
Council, are you perhaps confusing compensation for benefit sharing? What do the provisions of the Climate Change Act, and of course these are provisions in the latest amendment, Climate Change Amendment Act number 9 of 23, say about benefit sharing in the context of carbon credits?
That it is supposed to be equitable. However, I wish to stand guided, my lord.
Are you imagining, or are you telling us what the Act provides?
I am aware of the Act, but I have vitiated
Perhaps
knowledge
will you
of
start
it.
by telling us what the Act provides, then now conclude in that manner.
I stand guided.
No further question.
Much obliged.
Council, I will have no questions for you. I think my colleagues have been too tough on you. But because you like using the words "for the interest of justice," the court will grant you leave to file supplementary submissions for consideration next time. Thank you.
Thank you for your protection. I submit.
Council, you may proceed when you are ready. We are waiting for you.
Presiding Judge, members of the bench, good morning. Counsel on record is Lindsay Asiome, lead counsel for the respondents in this matter. With me is my co-counsel Mark Kiare, and together we will take the time allocated to us to respond to the claims made by the petitioners. I will respond on the first two issues in 14 minutes. My co-counsel will take the remaining time to respond to the last two issues. If the court seeks no clarification, I will proceed. To set context to this matter, Your Honors, the commitment to safeguard and uphold the rights of its citizens lies at the core of every government's mandate. And sometimes, this commitment necessitates a restriction on some individual rights and freedoms, Your Honors. Yes, indeed, land was taken from the petitioners, and yes, indeed, there was an implementation of the ECRN project, but, Your Honors, this was in pursuit of the greater good of environmental conservation and to alleviate the effects of drought and climate change on the community of Ramila. On the first issue, we respond and refute to the claims made that there was inadequate public participation and that there was an interference with the right to self-determination. On public participation, Your Honors, indeed, Article 69(1)(d) of the Constitution of Hazina requires the state to encourage public participation in the management and conservation of the environment. And indeed, we agree with the position taken by the petitioners that the test of public participation, as said in the Muikol Basin case, is one of effectiveness. We submit that on these grounds, the public participation conducted to involve the Ramila people was effective. I invite your attention to paragraph 15 of the Statement of Facts, in which we see a mass sensitization of the project happening, Your Honors. We see an involvement of the locally elected leaders, ranging from their members of the county assemblies to their parliamentarians. Additionally, the community members are encouraged to form community-based organizations, which we see being in use for the formation of the Solio Agreement, Your Honors. This only speaks to the steps that were taken by the respondents to ensure that as much as possible, the community has been involved in matters affecting them. And what matters at the end of the day, Your Honors, is that a reasonable opportunity is granted to the members of the community to have a say on matters affecting them. And this is a position which we have seen in the case of Minister of Health versus South Africa, and that which has been cited with approval in the Committee on the Formation of the Constitution versus the County Government of Nairobi. Your Honors, it is our position that indeed steps were taken to ensure that the members of the Ramila community have a reasonable opportunity to assess the matters of the implementation of the project before it is implemented. The petitioners put it forward that Regulation 17 requires the circulation of notices, radio advertisements, but, Your Honors, in the Merafong demarcation case, which was again cited with approval in the Legal Forum versus County Government of Nairobi, it was stated that public participation is open to innovation. This is to say, Your Honors, that context has to be taken into account. The counsel for the petitioners talked about circulation of notices. Your Honors, it cannot be gainsaid, it cannot be ignored that this is a pastoralist community. Where were the posters supposed to be taken? And that is why the respondents resorted to the formation of community-based organizations, which in the long run, Your Honors, enabled the formation of the Solio Agreement. Again, an argument may be put forward that there was a linguistic barrier, that there were challenges of the pastoralist way of these people. However, Your Honors, we have seen right until the implementation of this project and the conduct of the ESIA, there have been steps towards ensuring as much involvement of the people as possible. The mass sensitization was to enable them ask all the questions, every question they had regarding the implementation of this project, Your Honor. And on these grounds, we dispute the fact that has been claimed by the petitioners that public participation was not conducted. On the second issue, the right to self-determination, indeed, the United Nations Declaration on the Rights of Indigenous Peoples provides for this right, and it has been adopted indeed by Hazina 2004. However, Your Honors, Article 24 of the Constitution of Hazina has to be taken into account. The limitation clause provided in this article. Your Honors, limitations will be justified if they are proportionate, if they pursue a legitimate aim, and if they are necessary. We submit on this grounds, Your Honor, that the limitation taken of this right of the people was proportionate. Number one, it pursued a rational objective, and this rational objective is of environmental conservation. The principle of the doctrine, I beg your pardon, of proportionality was laid down in R versus Oaks and has been cited widely, for example, in Jacqueline Okuta and 3 others versus the Attorney General, heard before the High Court of Nairobi. This is to say that if the restriction pursues a legitimate aim, then it can be allowed. Your Honors, at paragraph 10, at paragraph 11, we are seeing contemporary issues arising with regards to environmental conservation. At paragraph 10, we see the effects of drought and climate change. We see the effects of human population. Paragraph 11, we are told that there is and has been a series of recurrent droughts in the state of Hazina, and the most affected areas are the arid and semi-arid lands. And this is why, even though there was a restriction, and we humbly acknowledge the rights of these people to self-determination, it was in pursuit of a greater good, their environmental conservation, and the betterment of their lives. And we have seen even the effects, the benefits of this project coming into fruition. For example, they have better jobs. As much as the petitioners have argued that this may be casual laborer jobs, they still have a means of sustenance, and this project has only been implemented for the past 3 years, and therefore, Your Honors, there is still room for better and better improvements, Your Honor. Additionally, we see the construction of boreholes and the construction of schools and the digging of boreholes, and this is only a testament to the goodwill exercised by the government in ensuring that not only the Ramila people, but also every single person, every single pastoralist community in Hazina realizes their socio-economic rights. And on those grounds, Your Honor, we submit that this limitation was proportionate. On necessity, we still take the same grounds, Your Honors, that the implementation of this project was necessary. Henry Le Bracton, in his writing on the laws of England, spoke of necessity as a doctrine that will legalize that which would otherwise be illegal. In this case, we have seen a necessity. The country is plagued by a series of droughts over the past 10 years. We have seen these people are affected by food. Refute the claims made that the implementation of this project was unnecessary. Your Honors, proceeding to the second ground, it is the respondent's position that contrary to the position made, the implementation of the ECRN project, as issue 2 says, was justified. Your Honors, again, I invite you to the limitations clause, Article 24 of the Constitution of Hazina. Yes, we acknowledge the rights of the Ramila people and indigenous persons to manage and conserve their environment. However, again, Your Honors, this right is subject to limitation. We take note of the fact that the Ogiek case was cited, and indeed paragraph 197 speaks to the requirement by government and states to protect and preserve the right to self-determination and the right of the indigenous persons to manage and conserve the environment. However, it is not absolute. The doctrine of paternalism would come into play, Your Honors, so that if there is a requirement to interfere with the rights of these people, then it is done. Proportionality, as we have well expounded on, the implementation of this project was proportionate to the objective. We are seeing the benefits accrue, albeit slowly, but they are accruing, Your Honors. They have better jobs, they have schools and boreholes, which initially they didn't have, and we see even betterment of the surroundings. We see the planting of eucalyptus trees, and we see that these people's general way of living has been improved, Your Honors, owing to the ECRN project, and we submit on these grounds, even though the benefits are accruing slowly, it is for the petitioners and the general Ramila community and pastoralist association to allow the respondents continue enabling them to realize their socio-economic rights. Lastly, we argue on reasonableness. The test for reasonableness was laid down in the Wensbury case, Associated Provincial Houses Limited versus Wensbury Corporation, in which it was stated that if an authority in relatively similar circumstances had similar circumstances facing him, if they would have taken the step they have taken, then it is considered reasonable. Your Honors, the implementation of this project was reasonable. Yes, indeed, we acknowledge that the petitioners and indigenous communities on the whole have a right to manage and conserve the environment. And we also take note of the fact that since time immemorial they have kept large herds of livestock, since time immemorial they have practiced their own ways of managing the environment. However, what would any reasonable authority do in this matter? Your Honor, we are plagued by food insecurity, recurrent droughts. The only reasonable way was through the implementation of this project, and we cannot speak enough to the benefits that are coming from it, albeit slowly, but they are accruing to the people. And on these grounds, Your Honors, we submit that the project implementation was reasonable insofar as environmental conservation is concerned, insofar as the preservation of the livelihood and the way of living of the pastoralist communities and petitioners is concerned. With that, the respondents ask this court on these grounds to dismiss the claims that have been made and put forward by the petitioners. With that, Your Honors, I invite questions from the bench.
All right, thank you. My first question would be, at paragraph 27, it is clear that local leaders led by Mzee Juma organized the pastoralist resistant march, and over 1,000 people turned up. You're citing excuses relating to linguistic barrier and their pastoralist nature. How did Mzee Juma manage to get 1,000 people for a protest while you couldn't? You only got the 12 elders and the mass sensitization, one mass sensitization. Does that really amount to the test of, is that creative from your perspective? Because you said, as Moi you have calls for creativity and malleability. Secondly, it was the contention of the petitioners that consent has to be freely given, it has to be prior and also informed. While they did not cite jurisprudence clarifying that position, would you kindly cite jurisprudence that clarify these three elements of the consent that ought to be given, since they went ahead to state that it has to be, for it to be free, it has to be free from any form of manipulation. And they state that you dangled before them tokens of fast-tracking registration of community land, which is something that ought to have been done anyway. It is not a benefit per se, but you promise this as one of the benefits that to accrue from the implementation of this project. And you have also stated that, these are your words, they have schools and boreholes that they did not have before. Paragraph 24 is clear that money has been set aside to be used to build 6 schools and 3 boreholes. Do they have these benefits? Thank you.
Much obliged, Your Honor. In response to the first question, the question on the 12 elders vis-a-vis the 1,000 people that showed up, it is the respondent's position still that there was the mass sensitization Your Honor has made reference to was enough. Your Honors, we see involvement of the locally elected leaders, from their parliamentarians to their members of county assemblies. This only speaks to the fact that the respondents exerted goodwill in trying to reach out to the people. And on the concern of the 12 elders being just 12, perhaps if you could draw a parallel to what happens in the United States and the United Kingdom, we have 12 persons as a jury. And the origin of this is that 12 persons were required to make a decision, and they were selected from normal people, Your Honors, not necessarily people who know the law. In this case, Your Honor, 12 is symbolic of divergent views. The first person would not embody necessarily the views of the second person, neither would the second person embody the views of the third person. And this is why, even relying on the concept of representative democracy, cited at Article 1 of the Constitution of Hazina, representative democracy should not be impeached just because the petitioners want everyone involved in public participation, Your Honor.
Well, I appreciate that argument, and I do not believe the petitioners have made any argument to state that they want everyone to be involved. Doesn't that argument negate the logic of the grounding of public participation in the Constitution in itself? While the Constitution recognizes that they are democratically elected leaders who act as representatives of the people, it went further to provide for public participation. And as the petitioners have cited, they have stated clearly that the people that are to be most affected by the project have to be the ones that are involved in the participation. So are these leaders the people that have to be most affected? And just an post facto analysis, they are grumbling, saying they have been denied their rights to access the cultural sites, watering holes, and there has been death, as also cited by the petitioners. So doesn't that still just go ahead to prove that their consent was not freely obtained, it was not prior, and it was not informed? And I had asked earlier, if you can guide us to jurisprudence that interpret the meaning of these words.
Much obliged, Your Honor. And indeed, the interpretation of free, prior, and informed consent was done in the Enderoy's case, and as well put by the petitioners, free to mean without coercion, prior to mean before, consent to mean they agree to the implementation of a project concerning them. In this case, we still hold the position, Your Honor, that what happened was free. Free for the sense that these people were given the benefits, yes, but they had the option to say no, or to accept or decline these benefits, Your Honor. Prior, it was told to them, the information was relayed to them before the implementation of this project. In R versus Attorney General, ex parte Honorable Francis Chachuganya, it was said that information ought to be available to the people. There ought to be dissemination of and access to information by the people to enable them make an informed decision. In this case, there was mass sensitization, Your Honor. During the mass sensitization, through their locally elected leaders, it was for them, Your Honor, to raise any concerns concerning the project. The question on schools, if I may, Your Honor, and boreholes, indeed, it has been promised to them, and it is the respondents before this court. They are already materializing other benefits, say the jobs. So it is only fair, Your Honor, before the respondents, to give them this benefit of doubt. The money was set aside. Neither do we see the use of this money in any other project. So it suffices to say that the money would be used for the implementation of the projects, the schools and the boreholes, Your Honor.
Just 2 clarifications from me. On public participation that we're talking about and representative democracy, I'm trying to understand the essence of public participation and why we have it under Article 10, whether it's supposed to be a check on representative democracy. You mentioned parliamentarians and elected elders representing these people. So in an ideal society, if you take 50 MPs and get their views, can that be considered as public participation?
Much obliged, Your Honor. And I guide you to paragraph 15.
It's a yes or no question. If you take 50 members of parliament and get their views, is that public participation?
No, it is not public participation.
Let us go a step further.
Yes.
If you take local chiefs of 20 locations and get their views, is that public participation?
No, it's not, Your Honor.
And that is the problem we are having here. Were there any other persons apart from chiefs, apart from members of the county assembly and parliamentarians, whose views were sought? And if any, when did that happen and where in the fact pattern?
Much obliged, Your Honor. As I was indicating at paragraph 15, if I may read verbatim, it is said that this was done with the help of the members of the county assemblies. We are not told that the participation happened for the members of the county assembly or on the members of the county assembly. Reaching out to these people, rightfully the subsidiarity principle would require the views of those directly affected. And here we are seeing help from the members of the county assemblies, parliamentarians, and administrative authorities to reach the people. Let us not ignore the fact that this is a pastoralist community. Therefore, reaching them would only happen through the locally elected leaders or the elders, as Your Honor has indicated, who are directly involved in the matters concerning them, Your Honor.
So these people can be reached through their leaders.
That is a position. Your
Therefore,
Honor.
the argument on linguistic barrier and movement does not hold water.
Your Honor, we acknowledge the claim made by Professor Ujanja on the linguistic barrier, but the problems that have been cited there are two. Number one, the linguistic barrier, but again, further it is talked about the pastoralist ways of these people. So in as much as perhaps, and that may have been an oversight on the respondent's position, that the linguistic barrier was resolved, there was still the glaring reality of accessing these people, yet the recurrent effects of drought are still being felt. The question of food security is still yet to be addressed, Your Honor. And that is why there was the necessity and urgency of implementing a project that would enable them realize their rights. Seeing that my time has run out,
My
I
second
request
last
for
question.
time. Yes.
On paragraph 21, before the license was issued, the law requires public, that is the MCAN, the regulations,
Yes.
publication of the same, the report, in at least 2 newspapers and advertisement in local radio stations.
Yes.
Was that done?
No, it wasn't done, Your Honor, but the respondent's position is this. Public participation is open to innovation, and this has been stated in the Merafong demarcation case and well cited with approval in Legal City versus the county.
No, we are not on public participation.
Yes.
We are on clear provisions of MCA and whether they were followed or not. So
In that-
it is the position on behalf of your client that you didn't publish in newspapers and you didn't advertise in local radio stations.
That is a position, and that is why we are relying on innovation, Your Honor.
Finally,
Yes.
and in light of jurisprudence from our courts, even the Court of Appeal, reasonableness in light of Article 47 of the Constitution, is it still Wednesbury's?
No, Your Honor. We only relied on the Wensbury principle as it was set out, but we have seen the use of this principle with approval in various cases, such as the Republic versus Public Procurement Administrative Review Board, and 2 others, ex parte Pelt Security Services. Therefore,
Which year? Which year?
This 2018, Your Honor.
Okay, thank you. That's all from me.
Thank you, Counsel, for the responses so far. I have a few comments and questions for you. You started off by telling us that the you are allowed to limit the rights and freedoms of your citizens by virtue of Article 24 of the Constitution.
Yes.
I suspect you're innovatively reading that section in the sense that it is not a blank check, or is it? Is it a blank check to limit?
It's not, Your Honor.
There are certain reasons that you can that are the only reasons you can utilize to limit rights and freedoms.
Yes.
And you mentioned them. What you didn't tell us is that limitations are as determined by law or as allowed by law. Which law allowed the limitation of the rights that you limited? The Constitution allows, but on the basis of law.
Yes. Much obliged, my lady. And we place reliance on Article 14 of the African Charter, which the state of Hazina has ratified, which provides that the right to property in this case may be limited in the general interest of the community and accordance with the set, and in accordance, I beg your pardon, of the set laws. In this case, it was for the general interest of the community. The benefits that would accrue to them outweigh the hardships that may have come through the implementation of this project, my lady.
So you're relying on regional law. Is there any local law or national law that allows that? And what you're alluding to seems to be that you're claiming compulsory acquisition. Is that the position?
No, it is not the position. And on the first question, Council is not aware of any national laws which would warrant the limitation of the right to self-determination.
All right, I move to the second question. I noted that you mentioned a lot of the use of innovative use of public participation. So as opposed to following the law, you innovatively come up with your own law. Similarly, you told us that you set up a 12-member bench, so to speak, of the community, similar to what the US does with their jury. And the question that came to my mind, is it the dog wagging the tail or is it the tail wagging the dog? Is the law made for the people or did you make the people for the law? If you have laws in your country, why are you not utilizing the laws? Why are you coming up with innovative ways of doing things? Is that legal?
Much obliged, my lady. And indeed, it is not the respondent's intention to go against the law. But in this case, and I reiterate the position in the Moot Basin local community case, at the end of the day, what is being sought after is the effectiveness of the measures that have been taken. The circulation of posters, for instance, per Regulation 17, would not be effective for the fact that they are pastoralist. Perhaps the writing of newspapers and the advertisements in the newspapers, for example, would not be as effective as gathering them. There is also provision for meetings with the local community to discuss the project, and this is what the respondents did. So in as much as our reliance is on innovation, we take cognizance of the provisions of the law, my lady.
All right. My final question is, you have mentioned that the reason you took the route of innovation is because of desperate times, calling for desperate measures. Yes. There was a lot of drought, hence the action that you took. But from our reading of the submissions made so far, it seems that the desperate times was for you to increase your revenue through carbon credits and basically have carbon revenue in your country. However, we note that you're taking this action pursuant to the Paris Agreement and the Carbon Market International Cooperative Mechanisms under Article 6. However, the Paris Agreement requires that any climate action that is taken must respect the rights of, among others, indigenous peoples. Would it be right to say that you have actually flouted your international obligations under that treaty?
Much obliged, my lady. The respondent's position to that is that we have not flaunted international obligations for the simple reason that, yes, indeed, there was a limitation, as we had earlier on alluded to, but it was in pursuit of the greater good. Yes, we are seeing benefits accrue from this project. Paragraphs 21, 22, 23 show us the plans for construction of schools, digging of boreholes. We also see the planting of trees, both indigenous and exotic, just to better the environment for these people. We are seeing an improvement in the ecosystem, albeit slowly, but it is happening, your lady. So we are not in contravention, and there were consultations with the indigenous persons, as earlier on submitted, before there was an interference with their practices. On these grounds, we submit that there indeed was no interference with their international obligations, my lady.
That is noted, thank you. Did you carry out a human rights assessment of your activities?
No, indeed, but my co-counsel will respond to that effectively.
Thank you.
Thank you, Council, for that presentation. As I ask my question, I'm a bit anxious that you tend to give answers to questions that have not been asked. And so I will try to be as slow and as clear as possible to enable you answer my question. One of the rights enshrined in the Constitution is the right to property.
Yes.
By dint of Article 40. Article 40 stipulates how that right can be limited.
Yes.
And the provisions of Article 40 are further fulfilled by the provisions of Section 107 to 133 of the Land Act. In this case, you arbitrarily deprive individuals of land to set up the Environment and Climate Restoration Now project without following the provisions or the limitations stipulated in law. Would you on that basis be justified to ride on Article 24 of the Constitution?
Much obliged, my lord. Our position is still that we were justified to limit that right, those rights, the right to property.
Arbitrarily?
Not arbitrarily, Your Honor.
Which law did you rely on to limit those rights?
There was no law we relied on, Your Honor.
So if you do not rely on law, then it is arbitrary. Then the second question would be, Section 59 of the EMCA, Environment and Management Coordination Act, stipulates that for an environment social impact assessment to be valid, it has to be published. Would it still be your position that what you purported to do was still valid in the absence of compliance with the mandatory provisions of law as contemplated under Section 59 of the EMCA?
Your Honor, there was no publication. However, the report was sent back to these people, and that is why it is our position that that was a compliance.
Section 59 is very clear.
Yes.
You should publish in at least 2 newspapers which have wide circulation in the area in which the project should be established. You should possibly go to vernacular radio stations because a language barrier has been cited. That was not complied with. So would it be right to say that your agent is actually an actor and an ambassador of anarchy, because he does not regard any law? Might is right. He's the government. He can do anything and everything.
Your
Perhaps
Honor,
in the scheme of the now famous Mambo ni Matatu phrase.
Your Honor, it is a position that no anarchy was put forward for the simple reason that, Your Honor...
But if you don't follow the law, aren't you being anarchic? Because the law is to protect all of us. But if you operate outside the law, then why should we have law in the first place?
Your Honor, in response, it cannot be overlooked that provisions of the law were followed. Article 69 1D was followed, requiring for public participation. There were consultations with the people even before the implementation of the project. So it therefore cannot be the position that the project was merely and solely for the benefit of the respondents. In fact, it was to mitigate the effects of drought, the effects of climate change.
I will allow you to think through, but that's the same scheme I pointed out. Now you're on public participation, which of course is different from an environmental social impact assessment.
Yes.
But point about it. Thank you.
Much obliged, Your Honor.
I have no questions for you. Thank you so much for your submissions.
I cede the floor to my co-counsel.
Presiding Lord Justice, esteemed judges, and we as the respondents cannot fail to acknowledge the ladies and gentlemen of the audience who are part of Hazina. Good afternoon to you all. Counsel before you is Mark Yarie, and I'll be presenting on behalf of the respondents on two key issues. The first issue is on the ESIA license, and the second issue is on compensation. And I beg, for clarity's sake, that you bear with me for 22 minutes of your time as I canvass my respective submissions. Esteemed judges, petitioners before you came with a vast litany of quotes from prodigious writers, to the extent that they quoted Marcus Aurelius. But the context here is, are we a court of law or a court of quotes? Because the context here is, we base our submissions on a simple yet impactful statement. The environment is a common heritage. And the validity of our statement is premised from the preambular clause of our constitution, the grand norm, as Lady Ombua well put it. And we have to be alive to the context behind Hazina. Drought is rampant, food insecurity, vegetation cover is low. And the ultimate purpose of the ECRN project, your esteemed judges, was simple. It was the preservation of intergenerational equity, because we are alive to our responsibility to preserve the common heritage, to preserve its carrying capacity for the developmental and environmental needs of future generations. And the benefits reaped from it are beyond any doubt. Access to employment, access to education, access to water, forest cover, and the seal of it all is reduced carbon emissions. And that is the heart to our submissions, and that is why we come before you today as respondents to canvass, to base our submissions to refute the two claims of the petitioners. The first claim we begin by refuting is by debunking the revocation aspect of the ESIA license issued by the second respondent. And the second issue that we seek to debunk is that the respondents failed to adequately compensate the petitioner in accordance with Article 43. But before we even do that, we noted the concern of this honorable bench on jurisdiction matters. And second counsel for the petitioner insufficiently demonstrated that they have jurisdiction to entertain this matter. We submit in the contrary, and we are alive to the contractual remedies under the SOLU agreement. We are alive to the statutory remedies existing. And I begin with the contractual remedies. When you look at these particular statutory and contractual remedies, individually, they will be ineffective because the context here transcends their jurisdictional mandates. But if you assess them collectively, and to give you an analysis, if they subject the first issue to the AJS, to the negotiation process, they can actually arrive at a decision that has no single source of ultimate authority or control, because the people actually have a say, the people can be consulted, and ultimately we will do away with these aspects of consultation, free, informed, and prior consent. The only issue that should be before this court is issue 2. We acknowledge that because of its constitutional aspect and constitutional right violation. Issue 3, on the other hand, Section 125 of EMCA establishes the National Environmental Tribunal. Section 129 vests it with the authority to dispense of, vested with an appellate authority to dispense of any appeals on the decisions of National Environmental Management Authority, that being the second respondent. And you look at Section 133 of the Land Act on the Compulsory Acquisition Tribunal, it actually vests the tribunal with appellate jurisdiction on land acquisition matters. Hence why we're saying when you assess them collectively, you actually find that the only issue capable of being presented before this court is the second issue. And in light of that, it is our submission that jurisdiction has not been sufficiently demonstrated for the fourth issues, only the second issue. We move on now to our key position, the first key position, and that is that the ESI license ought not to be revoked. And we are going to place reliance on 3 limbs. The first limb is that the respondents were actually largely compliant with the requirements of an ESIA in accordance with EMCA and its accompanying regulations. The second one is that we must assess the nature and scale of a project. And the third is that the benefits reaped from the implementation of this project outweigh the hardships, outweigh the need to renew the license. And we begin with the first limb on large compliance. And compliance on ESIA study report requirements is evident from Regulation 16 of the EIA 2003 regulations. And there are 4 in particular: public participation, effective mitigation measures, environmental management planning, and those are the only 3 actually that are in dispute in this context. And to complement the illustrious justifications offered by First Counsel for the respondents on public participation, we submit that to uphold this standard where the view of each individual must be deliberately sought, we'll be giving them a virtual veto power, in the sense that any proposal, any project, any activity can be quashed by the decision of just one person. And they relied on Muikol Basin case, Muikol Basin local community case. And on paragraph 297, we submit contrary to their averments, because we must accord with the nature of a subject matter. And to reflect on this, Martin Wambora case before the Supreme Court actually derived that you must assess the quantitative and qualitative ability of the primary stakeholders to understand the objectives of the environmental impact assessment. And in this context, their qualitative ability is what we had issue with, because we must assess the linguistic diversity, the cultural diversity, the geographical span, and the potential for transhumant pastoralism, because we actually have to assess their migratory routes. And all these things collectively have implications as to whether direct consultations was actually effective. And that is why she submitted that the representative role of the 12 elders and the chiefs was actually the appropriate technique to take, given the context of the subject matter. On the question of right to free, informed, and prior consent, First Counsel for the petitioners cited that free in this context means that it must be out of your own volition. And to paraphrase her, she used intimidation, coercion, all the likes, procedural unfairness. We actually go an extent further to demonstrate the justification behind the respondents' actions on substantive unfairness. And substantive unfairness in this context is on unconscionable conduct. And the question that I wish to pose before you, Honorable Bench, is whether the actions of a respondent, bearing in mind the provisions of paragraph 16, were actually unconscionable. We afforded them with a mass sensitization project. We afforded them with an opportunity to actually get access to the information on the mass sensitization project. We afforded them with the objectives. We afforded them with the benefits to be reaped from it. And the seal of it all is from the last statement of paragraph 16, that most of the residents from Rudolph actually consented to the implementation of the ECRN project. Bear that in mind. And in light of all that, demonstrating that we have to consider the mitigating impact, and we have to consider the social and environmental gains derived from the implementation of the ECRN project. And paragraph 22, paragraph 23, paragraph 24 demonstrate this. Because paragraph 22 demonstrates that we are alive to the depleting vegetation cover. And that is why we enacted on a forest landscape restoration. And First Counsel cited rather flouted averments on the need for eucalyptus tree. And this is our submission on this. Number one, and we have placed guidance on the International Union Conservation of Nature's guidelines on the various aspects and characteristics of the trees that they have outlined. On eucalyptus, number one, it has what we call carbon sequestration, meaning that it has the ability to store carbon in its roots, reducing this presence of carbon from the atmosphere. Number two, it's quite common knowledge that trees are a heat sink, meaning that they will utilize the carbon in the atmosphere to photosynthesize their food and ultimately replenish us with oxygen. So if anything, they ultimately contribute to intergenerational equity. We move on to the aspect of us planting both exotic and indigenous trees. And this is behind the very purpose of the ECRN project. And this is on ecosystem restoration. And ecosystem restoration has no definitive limits. It's all about flexibility. That is why we are planting these eucalyptus trees, to reduce the carbon emissions. The carbon emissions being reduced, we get rainfall. To get rainfall, we get the grassland cover. And when you get the grassland cover, they can actually we actually facilitate their ability to be transhuman pastoralists because they can actually graze. And that's why we're trying to do away with this unsustainable practice of overgrazing. And to justify all that, we are demonstrating to you before this court that on the first key limb on compliance, we are actually in compliance with the regulations and the prerequisites that have been set out therein. We move on to the second limb of the first key position, and that is on the nature and scale of a project. And we peg your focus to paragraph 18 of this Moot record. This particular project was mapped out over a 6,000 square kilometer radius. And it is quite significant that we place reliance to the National Environmental Tribunal's decision in Greenbelt Movement versus National Environmental Management Authority 2020. And we're actually going to place reliance to the context, not necessarily any dictum whatsoever. Because the context here was that the petitioners were aggrieved or disgruntled by what they called the inadequacy of the ESIA study report conducted by the respondents regarding the expressway of the Kenyan government, of the Azanian government, apologies for that. And the context here was that they had not actually undertaken a climate risk assessment pursuant to Section 20 of the Climate Change Act. They had no environmental management plan. They had no human rights assessment, but the tribunal, in its wisdom, assessed the cost effectiveness of having to renew the license. And I will quote them in paragraph 117 that they said that an EIA or an ESIA study report entails a colossal amount of public funds and resources. And having to renew this process all over again will be detrimental, given that we are already in compliance with the vast majority of the requirements needed of us. Therefore, this will be detrimental to public resource use, public resource management. And in light of that key limb, we hope that you do bear in mind the cost efficiency aspect of renewing the license. And we move on to the third limb on the benefits reaped from the ESIA project. And we are alive to the establishment of the boreholes, the establishment of 6 schools. And we do actually bear, in fact, general comment number 13, or before the Committee on Economic, Social, and Cultural Rights, on the 4 A's governing the right to education as encompassed in Article 13 of the ICSER. So the 4 A's in this context, 2 are of particular significance to us: availability and accessibility. And we do acknowledge that 6 schools is not enough given the radius of the 3 counties, but we must be alive to the progressive aspect of this. And the Office of the High Commissioner for Human Rights in 2005 devised a set of principles and guidelines on a human rights approach to poverty reduction and management. And in this context, they were alive to the poverty situation that is deeply entrenched, apologies for that is deeply entrenched in our particular context. And it would be unrealistic to actually expect the respondents to actually establish 6 schools within a span of just a year. It takes time. And that's why the 6 schools were just established over 3 years. To expect us to establish more than 6 schools within 3 years would be extremely impractical, given that you are utilizing the maximum extent available of the resources on hand. And we also have to consider the forest restoration landscape, the vegetation cover. We have to consider the access to employment, and albeit in as much as it is as casual laborers. Being a casual laborer is not synonymous with low income. Quite the contrary. Casual laborers actually demonstrates our desire for inclusivity, because we give you this comparative analysis. What if we just give these jobs to the 12 elders for 365 days? What happens to the rest of the indigenous populations, indigenous pastoral communities? That is why it was on a rotational basis to actually implement access to employment. And you'll find that in reality, we are trying to implement to fulfill our obligations under Article 56 of the Constitution. Offer them access to water, albeit progressively. Offer them access to education, albeit progressively. Offer them access to employment on a rotational basis. And the best part of it is that we are actually complementing their cultural practices, because this vegetation cover is being replenished to allow them to conduct grazing habits. But then we have to control the grazing habits, as the second council appropriately put it, because it will eradicate the possibility of intergenerational equity if it's conducted on an immense scale, quote unquote on overgrazing. And in light of those submissions, we ultimately urge you as or the honorable bench to consider the fact that cost effectiveness, the benefits, the large compliance with the ESI requirements actually justifies that the revocation of this ESI license would be unnecessary given the context at hand. And we move on to my final issue that warrants your attention. And the question that still remains to be answered by the respondents is simple. Did we justly compensate the petitioners in accordance with Article 43 for the land acquisition? And for context, and as a preamble to second counsel for the petitioner statements, the factual context of the Kenyan government has no particular relation with the factual context of Hazina. What we have in this context is the laws replicating the Hazina, the laws that Kenya has replicate Hazina. And why do they say this? Because they place reliance on the value of the dollar, which to us seemed so inconsequential and so irrelevant. And hence why we are concerned with one thing here, quantum of compensation. And the quantum of compensation is pegged on the long-standing objectives of equivalence and equity. And the principle of equivalence was defined by the Pratik Musimba versus National Land Commission case of 2016, whereby it held that you are entitled to compensation as the interest holder for the losses attributable to the taking of your land, but no greater amount, because that would amount to improvidence, that would amount to unjust enrichment. But the petitioners fail to understand that concept, and we seek to introduce a certain new argument to you in the sense that the term compensation should be given its broadest meaning, and the broadest meaning here is benefit sharing. And we rely on paragraph 296 of the Enderoy case in this context, because benefit sharing serves as an indicator for compliance with the right to property, particularly compliance with the right to the obligation to duly compensate for interference with the right to property. And the benefit sharing in this context must be mutually acceptable. And as I demonstrated earlier, the right to free, informed, and prior consent has actually been demonstrated. And the mutual acceptability is, one, paragraph 16 demonstrates that they were amenable to the benefits being derived from the ECRN project. Paragraph 22 demonstrates that this forest cover actually benefits their grazing habits. Paragraph 23 demonstrates that they actually were afforded an alternative system of livelihood, that their means of income, their living standards would not have diminished whatsoever, that we're actually trying to preserve their well-being. And paragraph 24 seals this all because it offers us a situation where we have generated 6.8 million carbon offset revenues, demonstrating our desire to reduce the carbon emissions, demonstrating our desire in accordance with the Paris Agreement to actually attain the global peak of greenhouse emissions, and ultimately intergenerational equity. And that is why in our submissions today we submit that in the adequate compensation that we present before you has actually been demonstrated, contrary to the petitioner's averments. And with that said, and as we depart the floor of this honorable court, unless there are any questions, we leave with these concluding remarks. That climate change has been a menace to our social fabric. Our submissions have presented that. But if they are allowed to continue with these unsustainable practices, what then? Will we reap what we sow? Will we continue with drought? Will we continue with food insecurity? Will we continue with deplenishing vegetation cover? Will we be ultimately in contravention of our international obligations? Because under the Paris Agreement, it's quite simple. Duty, common but differentiated responsibility, meaning that this is an acknowledgement that the environment is a common heritage that must be preserved by all. Thank you for your time and attention. I'm open to any question.
Thank you very much, Council, for your submissions. Two questions from me. One, paragraph 8 and paragraph 9 of the fact pattern describes the Ramila community, and they are noted as being the most notable communities living in the northern part of the country, and paragraph 9 also speaks as to their way of life. So why then are we citing the issue of language barrier and their pastoral nature? It's like the government just discovered that they speak a different language, and they just also discovered that they are of a pastoral way of life. Isn't this something that was already known and ought to have been taken into account when the public participation for the purposes of the ESIA was being conducted by Professor Ojanja.
Yeah.
Secondly, is the question of the cancellation of a license and the requirements for the ESIA, are they questions of procedure, or are we to sit down and analyze the benefits of this potential project when deciding whether to cancel or not cancel the license? Your first counsel admitted that the procedure that is laid out, that includes publication and even announcements in vernacular, was not done. So are we to sit down then and start analyzing, as you have vehemently submitted to us, on the benefits of this project, and fail to look at what the law provides, what is the procedure for the conduct of an ESIA, and if this was complied with or not, then we revoke that license, or we cancel the license. Thank you.
I'm most obliged for your two questions. On the first question, we rely on the working group behind the African Commissions on the Rights of Indigenous Persons. And they established four criterion, a four-stage criterion on defining who are actually indigenous people. And the key significance here is that the fourth criterion, the last criterion on this, is that they must attain recognition by other people of their vulnerabilities, that they are actually excluded from being integrated with our economic and social life. And therefore, in as much as it was our burden to craft a public participation program that must adhere to this, to their way of life, to their transhuman way of life, we must consider the qualitative aspect of it. We must consider that they actually have well-established institutions, a customary decision-making process, otherwise they would not have any 12 elders. And these 12 elders are not actually isolated from the transhuman way of life of the petitioners. If anything, they are part and parcel of it, because in the alternative aspect, we could have actually just relied on the county assemblies and the parliamentarians, but we went deeper. We went to the elders because they understand the close connection they have between the natural resources and their way of life. And on the second argument on requirements, I place emphasis on the second limb of our key position, on our first key position, cost effectiveness. Because in as much as the legality is at the forefront of this, does the benefit outweigh the hardship? From our submissions, that is our position. And in light of that, will this be cost effective if you were to renew this license? Bearing in mind, number one, that these resources could be diverted towards actually identifying or realizing the prevalent drought in the region. They could actually be utilized for that rather than having to renew the EI license again.
Would it not then have been cost effective for you to just follow the law in the first place?
I beg your pardon?
You would have just followed the law in the first place, right?
Yeah.
Yeah, and even as you have answered my first question, are you trying to impugn their status as indigenous people?
No, not particularly. We are not advocating that they are not indigenous people. I was trying to demonstrate that their vulnerability actually makes them not be integrated to the economic and social life, that they are marginalized, essentially. That was our submission on that.
Thank you. Just two from me. First, again, is on the jurisdictional question of issue 3.
Yes.
First is on jurisdiction. I understand this case is before this court as an ELC petition.
Yes.
Correct?
Yes.
And all the issues here are related to violations of the petitioner's rights. That is correct?
Yes.
Now, in the Ken Kasinga case, the ELC was of the opinion that where we have issues that are intertwined to violation of rights, it is proper that the matter just goes to the ELC without a necessity of bifurcating some to the net tribunal. Is your submission going to go contrary to that clear position by this court?
Not necessarily, and we respectfully beg to differ with not necessarily the judge, but that particular implication, because we acknowledge mutual comity between the courts and the statutory remedies put in place. And the court cannot always be the first port of call when a storm brews, in the sense that they actually overlooked the contractual remedies. They actually overlooked the statutory remedies, and any concerns that exist as to subdue this rule or legally dependence cannot actually exist in this context because they have different jurisdictional mandates. That means that you can actually be at the negotiation process, still be at the National Environmental Tribunal, still be at the Compulsory Acquisition Tribunal, because there is no subjudice in this context. They are all...
The major remedies that the petitioners are seeking are grievances against violation of their rights.
Yes.
Can they get a remedy against the violation of rights in alternative justice systems?
And we were alive to that, and hence why I said on issue 2, because this transcends just the private rights. It integrates a public interest aspect in this context, and that's why we acknowledge that issue 2 is rightfully before this court. But the other 3 issues could be dispensed with on other alternative forums, both statutorily and contractually afforded.
That will be cost effective. Now that you're speaking about cost effectiveness.
And on that particular aspect of cost effectiveness, we still submit that, again, it's back to mutual committee. And we have to consider that in as much as they would expend quite a lot of resources here, they were available. The remedies were available. They are effective because, as I've demonstrated to you, if you look at them holistically, there will not be any inadequacy of relief. And ultimately, contrary to Second Council's fallacious averments, they are not insufficient, because I demonstrated that the Greenbelt movement case before the National Environmental Tribunal actually decided upon the expressway matter.
Thank you. I think I follow your argument on that.
Okay.
Just a quick one. Was the climate change assessment conducted?
No.
So, and the Climate Change Act demands that the same be conducted before implementation of such a project, right?
Mm-hmm.
So
Yes.
with those admissions, then we should dismiss the case.
And we noted the concern, and hence why I relied on...
No, it's not a concern. It's a clear violation of the law you have admitted. You are not supposed to do a project without doing a climate change assessment. You did not do the assessment. What are we supposed to do with the license?
I'll respond with a rhetorical question in this context. Does the ECRN project ultimately contribute towards climate change mitigation, bearing in mind the carbon offset revenues?
It's rhetorical. I will not answer.
Exactly.
Finally, I'm trying to understand your last submission on benefit sharing vis-a-vis compensation. And it's the question that the Honorable Judge put to your co-counsel. What are we exactly looking at here in issue 4? Because Article 40 clearly mandates the state to compensate promptly where land has been acquired. So we're talking about the community land that was acquired. Was there compensation for the same?
Yes.
Promptly.
Promptly, in our context and in our humble but considered opinion, should be given a very passive interpretation to it, to include continuing benefits, because access to employment is a continuing benefit.
So wait, I'm trying to understand something here. When assessing compensation for compulsory acquisition, isn't there a formula of how to do valuations of the same and appropriately compensate, or do you consider the benefits of the project and call it compensation?
And we respectfully beg to differ on one thing that we wish to clarify. This is not a compulsory acquisition matter, because they actually consented to us to use. And
so you're saying it's a surrender?
Not particularly. It's an acquisition of land. Acquisition, not compulsory. Just acquisition. And given the objective...
Just a minute. The law is clear, the Community Land Act, Section 22, on how community land can be given to the government. Mm-hmm. So which one is it of them? We have compulsory acquisition, we have surrender. So which one is it?
Well, we have to place guidance to Article 43 of the Constitution, because it says that you cannot be deprived of your interest rights over land unless the acquisition was in the context of Chapter 5 of the Constitution. And Chapter 5 of the Constitution breathes life, pursuant to Article 63, to the Community Land Act.
Article 43 talks about compulsory acquisition. It's okay, thank you.
Most obliged.
All right, thank you, Council. You've mentioned that the reason you took all the action that you did was to meet your Paris Agreement obligations. That's one of the fundamental reasons.
Yes.
And you're claiming that you are taking action to meet your greenhouse gas mitigation target.
Yes.
What is your greenhouse gas mitigation target? And where is it found?
The nationally determined contributions in this context, I have to stand guided on that. We may not be aware as to the precise limits of it. Nonetheless, we still have to consider international cooperation. We have to consider the principles of equity, and equity in this context is being alive to Article 69, to that we all need to cooperate in eradicating this menace.
But I agree with you. Do your NDCs also mandate you to carry out all your action with a human rights lens?
Yes.
Does vulnerability, is it mentioned in your NDC?
Not particularly, but we are alive to the fact that we still need to conduct our activities bearing in mind our need to protect human rights.
It is actually expressly mentioned in your NDC. And so you cannot cherry pick which sections of the nationally determined contribution you adhere to and which ones you do not. It's an entire wholesome package, and you do not have the option to cherry pick. More so, you have mentioned the Paris Agreement. What is your obligation to persons in vulnerable situations as far as that treaty is concerned?
Under the Paris Agreement?
Yes.
Well, we have to consider, number one, we have to protect or preserve their unique context, in this case, their cultural distinctiveness. But we are not, and that's why we are not advocating to completely extinguish grazing.
You will only, just a little.
Yes.
Just a little.
Just, yes. We are condemning overgrazing, but not grazing.
All right. That's noted, but you have to bear in mind that human rights are indivisible, they are interrelated, they're inalienable, they are universal. Based on that, you mentioned a lot that you are carrying out your activities, and your opening remarks were about the need for intergenerational equity. And throughout your submissions, you weaved in intergenerational equity. Do the rights of future generations take precedence over the rights of indigenous people who are presently here with us?
We're not that concerned, but it's a balance of interest. A balance of interest in the sense that, and we place reliance to the Enderoy case, while you are engaging in pursuance of a right to development, you must acknowledge the need to preserve the enjoyment of other rights. And it outlined 3 stages to the right to development while interpreting Article 22 of the African Charter on Human and People Rights. Consultation, evident. Free, informed, and prior consent, evident. Compensation, evident. And therefore, we have actually tried to attain that balance, that proportionate aspect of it.
True, but when you're protecting the rights of future generations, do you only protect their rights as far as environmental conservation is concerned, or do you also protect other interrelated rights, like their right to culture? Do they have a right to be born and find that the culture of their forefathers is still in existence?
And yes, because there are certain immutable aspects that actually define the petitioner's cultural elements, and we are not trying to eradicate those. They demonstrated.
Your actions seem to suggest otherwise, but we shall proceed. Okay. What principles on the rights of future generations have you had? What basis? What are you basing your action on? What international instruments inform how you pursue the protection of intergenerational equity?
Well, we have to place reliance on a soft law of the Rio Declaration, and Principle 10 actually advocates for public participation that is commensurate to appropriate access to information.
No, let's not go to public participation as the hammer that we are using for every question. What international principle? You can use the Rio Declaration, but let us not go to public participation. Okay. I'm asking about intergenerational equity.
On intergenerational equity as a concept itself?
Yes.
Well, we still place reliance on actually 2 of them, the Stockholm Declaration and the Rio Declaration, because the first thing we need to understand is that the environment is a common good. It has global ramifications. That's number one. And the Rio Declaration poses that in principle one. Number two, cooperation is particularly inevitable. It is prudent. It is imperative. And third, equity in this context necessitates that each and every one of us have their own share, have their own place, have their own role to play in combating climate change, in combating these environmental detriments and environmental effects that come before us.
All right. Did you review the Maastricht principles on future generations?
I stand guided on that.
All right. Please have those in mind when you're taking any action to protect future generations. The protection of future generations cannot and must not be done in a way that does not protect the rights of current generations. What is the basis of balance? How do you balance those rights?
Well, that goes down to the First Council submissions on proportionality, in the sense that we are trying to create, we're trying to preserve the carrying capacity of the environment to meet both the current generation and the future generation, to preserve both the rights of the indigenous persons while complementing or advancing their cultural practices. And we place reliance on Article 69, or 1 of the Constitution, because we have an obligation to actually have 10% of our land area forested. And that is why, pursuant to paragraph 22 of this fact pattern, we are trying to progressively implement that. We are.
All right. Do you have any case law that could persuade us that the action you're taking to protect future generations is the right action?
Yes, and on a separate opinion by, her name escapes my mind, but in the Lubicon Lakebird case before the Committee on Civil and Political Rights, an established judge before that committee said that the right to enjoy culture by indigenous people should not be implied to be understood that it should have precedence over everything, over anything, in the sense that it should not be implied to be understood that their traditional way of life should be preserved intact at all costs, because that will jeopardize the economic development, the social developments, and the political developments of the rest of the population. And seeing as I believe my time has expired, yes, we do acknowledge and apologize for the time expiry, but we do hope that you may grant us leeway to just wrap up on any questions that may be warranted.
In as much as your time is up, you are still subject to you still have to respond to the questions from the judges. So we'll proceed.
Yes, most obliged.
Okay, thank you. I will have only one question for you. You warned us that the applicant stated that started by making several quotes, and you warned us that this is a court of law, not a court of quotes. But how do you uphold the law when you do not follow it? So one thing I'm interested to know, was a community development agreement concluded as a basis of the carbon offset credits, 6.8 million carbon offset credits that you are flaunting to justify your actions?
And we understand the corpus of that question arising from Section 23 of the Climate Change Act, but we must consider that
was it concluded between the government and the community?
The agreement itself.
It's a simple question.
Yes. If you look at paragraph 19 of the fact pattern, the first statement, unless I've misunderstood the question.
And what is your first statement?
It essentially talks about that the Salio agreement was signed between the community-based organizations and the national and county government.
Does that amount to a community development agreement within the meaning of Section 23 and 5 of the Climate Change Act?
We must consider the terms of reference to this particular agreement. And one of them, still under paragraph 19, was that they were to enjoy the proceeds arising from tourism and the carbon offset revenues generated by that
Doesn't
particular
that
credit system.
section stipulate the obligations and what must go into that agreement?
Yes, it does.
Wouldn't you agree then that this is more of a political creature and less of a community development agreement?
We respectfully beg to differ with that. It's not a political symbol. It's actually a way to champion for the rights, for the needs, for the development of society.
Thank you. No further questions. I'll return you to the presiding judge.
Most obliged.
I will ask this question because you made reference to a particular decision. The case of the Greenbelt movement at the tribunal, you were quick to refer to the aspect of cost effectiveness. But in light to your case, to the case that you're presenting, the response in respect to this petition, are you aware of the holding of the tribunal in respect to the the environmental impact and social assessment that was submitted by the proponent in that particular case?
On the Greenbelt movement case?
Yes.
The EIA itself?
Yes, the holding of the tribunal.
Concerning the
Yes, that
ESIA
was
study
submitted.
report itself? Yes,
Yes.
and they said that they were largely in compliant with two aspects, public
Yes.
participation
Yes.
and the mitigation measures.
Yes. So when you have that in mind, do you still equate the same conclusion on your cost effectiveness in this particular case?
Yes, because similar to our position and similar to the context at hand, we are actually effectively dispensed on public participation, and the impact or the social gain, the environmental gain, and the intrinsic gain from this particular ECRN project is evident.
Yes. But in my response to your colleagues, you duly confirmed that there was no adequate public participation and compliance with the law on the entity that you are presenting. Was that the position?
I beg your pardon?
And I'm saying earlier, in response to the questions that you asked by my colleagues, you clearly confirmed that there's no compliance to the law by the entities that you are representing in court. Was that the hold?
With respect to public participation?
Yes.
And if we are guided by the legal construct in its rigidity, then yes. But if we are to uphold the flexibility standard of Muikol Basin and of Martin Wambora, of Justice Sachs in Constitutional Court of South Africa, then no.
Okay, thank you. That, I think, is the only question I had from you. Thank you so much.
Most obliged for your time and attention.
Thank you so much, Council, and the community of Hazina, together all the parties who are present. I think this marks the end of our proceedings for today. The court will return to make its assessment, and we shall be back with a decision. So we hand it over back to the organizers. Thank you.
Yes, thank you. As the court retire to render its judgment, we can wait for further direction. The court, my lord, we can move this side.
Good afternoon to the participants. We are also recording a podcast, so we'd want a few of the participants who want to participate in this so that you can be recorded just how the competition was and if your expectations were met. So I'm looking for a few volunteers, about two. So So if you're interested, just reach out to me. Thank you.
Breathed a lot of hot air.
And we are not going to move an inch from our cradle land in Loliondo, in Simanjiro.
They burned all our houses, including the school uniforms, the school books. So I missed the school several times until I asked myself what is happening.
And we are ready and we are more than energized and we are moving forward because our God has not told us to stop.
I think their resilience is incredibly inspiring, considering that they're the ones on the front line doing this, and we're really only just coming in to offer support.
It is labeled as the longest heated pipeline in the world. The East Africa Crude Oil Pipeline, a 1,443-kilometer pipeline that is primed to transport oil from the Hoima fields in Uganda to the Tanzanian coastal city of Tanga.
Thank you for responding to my invitation to join us and the Total Company of France and the Sinopec Company of China to sign the agreement of the East African pipeline from Hoima to Tanga.
I'm quite conversant that prior to the implementation of this project, there are still pending issues that need to be addressed. And in this regard, I urge all parties to work together to address the remaining issues to ensure the expeditious start of this project.
Residents in Tanzania and Uganda were promised that the oil pipeline would bring with it social and economic transformation.
Kwa hiyo kwa namna moja ama nyingine unaweza ukaona kabisa yale mafuta yanayozalishwa Uganda hayawafaidishi watu wa Uganda. Yatachukuliwa, yanasafirishwa kupitia Tanzania, yanaenda kwenye nchi zingine, huko China, yanaenda Ufaransa, na mwishoni yanasafishwa, ndipo tunaletewa sisi na tunauziwa kwa bei ya juu zaidi.
We've seen so much destruction, especially the national park where the infrastructure for the ECOP is passing through. And then remember, these communities entirely depend on land. So our homestead without land, it's really a gone one.
In Uganda, all these remain pipe dreams, unreachable to residents of Hoima, Bulisa, and the greater Masaka regions. Oil spills, pollution, corruption, and other negative effects on the broader ecosystem, all dangers communities face.
What about the displacement? What are you saying now?
Land and environmental rights defenders have raised concerns about the possible environmental and social impacts of the pipeline.
What are you saying now?
Yeah, that is my former village, and the house you're seeing in blue, that was my primary school. That's where I went through my primary school.
Christopher Opio's village in Kabale is among those through which the pipeline passes. The construction of the pipeline has displaced 7,000 people in his region. He had to start a movement so as to defend his village.
The journey, oh my God, it wasn't easy. Now, what happened in 2012 when we started this movement, it was a pressure group. We used to call it pressure group, and even government were calling us, pressure group. So in 2012, when we started our movement to fight for our own rights, now it was a big challenge.
The government is preventing residents from utilizing their property without compensating them. Schools have shut down, leaving the students in uncertainty.
So you can imagine from 2012, a child that was in primary 5 to up to 2018 would be in a secondary school. All these children dropped out of school. By the time they came back here, they were already grown up, young girls and boys.
twayebuza aha bwacu refinery yizira aha bwacu amashitagiziro mu Uganda gakagizira ki kare twashemererwa aha bwa project ege yabireho twabona abana barwo mu mashomero ababire bahika bakwata umuhanda baza kushwerwa bacyari abana bato n'abashija batusigaho batusigireka bakwata umuhanda bagenda.
Just like Christopher Opio, Robert Birimuye, a farmer in Chotera, Greater Massacre region, continues to be the voice of more than 2,000 people who have placed their trust on him.
Imagine somebody comes and tells you that this land I'm going to give you, let's assume 50,000. But you've not talked to him to know you how much do you want. It is them who raised the price. For us, we just received the wrap forms that your land is going to be weighed under this.
Robert took the war to the law-making bodies in his country, petitioning both Parliament and the courts on behalf of those affected by the project in his community.
Many people fear, but it is you to decide. But many people fear. You should have the heart which is hard as a stone. Because for me, I signed already the letter of death.
Robert is not alone in his quest to free the people. There are others like Kayinga Mudu Yesto, who leads a community network focused on human rights protection, land ownership, oil and gas management.
We said what happened in Bunyoro will not happen in Gweta Massacre. It's the reason why I became tight in Gweta Massacre. I told them, under my dead body, as a son of Gweta Massacre, we have learned what has happened in Bunyoro. We have learned what I benchmarked in Nigeria, I benchmarked in Turkana in Kenya. I said what we have come to learn about oil extractives in Africa, they are not, they don't have any difference. It is just the same. Mafiaism, impunity, marginalization of the communities.
Although the push to stand for their rights has come at a cost, the defenders are not backing down.
My office was raided and my home. But why? I insisted that no rights of people in Gweta Massacre should be manipulated. Then it came to blackmail, threatening phone calls, surveillance around my home and my office.
Land and environmental defender Maxwell Atuhura fled his home because of continued arrests and harassment after petitioning the government on behalf of the Bulisa community.
I've been arrested and spent some days in cells because of this work. I was arrested in 2021 in May and spent two nights in cells. I was charged for unlawful assembly.
Bulisa is central to the East Africa crude oil pipeline. It is a district where most of the oil is located. Over 27% of the population in this region has been affected. The pipeline could lead to the loss of natural habitat and biodiversity and significantly alter migration patterns of wild animals.
Frying of the gas, testing of the oil. It came with burning the oil, the heat was too much to people, and it changed the area in one way, the other. Now they have gone, from that stage they had to go on another stage of acquiring land in sensitive areas. This area is one areas which are rich in biodiversity. So there are many biodiversity which are tampered with. You find that some oil wells are even in the middle of Murchison Falls National Park.
Alice Kazimura, an environmental defender in Bulisa, vows to push on.
Initially in Bulisa, we were not having land conflict, but now we have a lot of land conflict. If you have got to go to any court, most of the cases are on land conflict, because for us your land was owned communally. You could come, you say, hey, but I want to construct my house there. I said, you construct, there's no problem. We are not having boundaries. But now, it is so tight with the oil, everybody must have a boundary. So we are having that problem of land, and women have faced this stuff because men are selling land without mercy. And sometimes the other men, when they sell, they just move and leave you there with their children and remain to suffer.
This petition is direct.
For them to be heard, defenders have been forced to amplify their voices.
For those people who can have a voice for others, they should speak for others, because you have many people who cannot talk for themselves. They have issues which are pressing them, but they cannot speak for themselves. So people should come out and speak for others. People should come out and make voices for others, be the voices of the voiceless.
What we're doing now, we have seen that the company may not do what we want. We want total justice. We know we may not have justice in Uganda. We need to look for justice from elsewhere.
Amplify them across borders to the ears of those who make decisions on behalf of their oppressive regimes.
My activism started because of what I was going through, what my family was going through, and what my community was going through.
Speaking on a woman perspective, every time I look at a kid suffering, I also think about my kids at home. I'm like, what if this also happens to me one day? Because there are situations and conditions that no human being would really want to go through or to face. So when you really visit those communities and you listen to them and you look at them, it really gives you more courage that I will fight and fight for them and on their behalf and with them, so that at least their livelihoods are improved.
I'm born to do what I'm doing. And I was telling people, no one can stop me to do what I'm doing. It is only God. Even if they are money, even if the companies are they are a lot of money, they are intimidation, talk about your guns, what have you, nothing will drain me from fighting and defending rights of the communities affected by ECOP.
They can only hope that someone out there listens, that someone out there acts to turn their strength into hope, not just for them, but for defenders in neighboring countries. In Kenya, just like neighboring country Uganda, defenders are steadfast in their determination to not be silenced. The once peaceful atmosphere of this region is now being disrupted as they stand firm in their convictions. The Moot forest in Kenya's Rift Valley is one of the largest uninterrupted blocks of indigenous forest remaining in East Africa. In 2009, the Kenyan government declared that deforestation had endangered the viability of the water catchment within the forest and that all residents had to be resettled. This meant that the Sengwer, an indigenous community who had called this part of the world home for more than a century, had to find alternative homes.
It looks like a forest, but it's not forested to us. It is a land that is forested to Sengwer community. That is what it means to Sengwer community.
The right of the Sengwer to their land in Embabut is protected by the Constitution of Kenya, which defines ancestral land and lands traditionally occupied by hunter-gatherer communities as community lands. Government-ordered evictions of these communities continue to separate them from their spiritual and cultural practices in the forest and putting their very culture at the risk of disappearing forever. The Kenya Forest Service, a statutory body mandated to conserve and manage all forests in Kenya, has been carrying out forced evictions in Embabut since 1980s, burning houses, displacing hundreds, injuring many, and even killing.
I asked one of my grandfather, why are they burning us and the houses in the other side are not burned? So they are telling me that government gazetted our forest, our home as forest. And we were forest dwellers since time immemorial.
Elias Kimayo, who identifies as a Sengwer, has been on the front line, responding to the forceful evictions and accompanying human rights violations.
First, when we were evicted in 2014, all these forests was covered up by caves. They could not allow where you passed by. So there were roadblocks not to allow people like you or any media houses or any CSOs people to come and see the challenges that the community are going through. So what they did was like they closed all the forest and they come now to burn people's houses, arrest people, take price from people, steal people's cow, sheep or goats. Then I was left wondering how can the world know about these atrocities that my community is going through.
On the 2nd of April 2017, Elias was filming Kenya Forest Service rangers from a distance as they burnt houses in Embabut Forest.
I almost also lost my life because of that work, because when they came and discovered I was the one who was filming them burning houses, so they tracked me down inside the forest. So and they ambushed me in 2017. So they almost killed me, but I survived. Because I survived also, so I continued, because if I had died then, that could be the end of everything, because God gave me a chance to, because they needed, the community needs me to still do this work in order to, so that they get their rights.
In January 2014, or this year, Your Lordship, the respondents descended on Embabut Forest and evicted members of the Sengwer community, destroyed their property through burning, and even used force.
Government officials claimed that the Sengwer were consulted fully through the Embabut Forest Task Force process and that they consented to the eviction.
First of all, eviction. There's no proof that they were evicted, because if you read the affidavits, they are stating that they ran away themselves.
Between December of 2017 and April of 2018, community representatives reported that armed Kenya Forest Rangers burnt down an estimated 341 houses. Now, the community lives in constant fear. Fear that has now turned to strength.
So I encouraged the women to speak, because they were like, if I speak, they will point me. Or if there were journalists to come, they will see me on the TV. So if they see me on the TV, they will come and maybe target us. So I started encouraging them, and then we compose some songs and then go to court.
Strength that comes from the African Environmental Defenders Initiative, a movement dedicated to elevating the work of environmental defenders and ensuring their human rights are protected. The initiative works to minimize the risks faced by defenders by offering support to enhance their resilience. Fueling this effort, Natural Justice has created the African Environmental Defenders Fund through the initiative, adding even more muscle to this cause.
The self-assurance of someone having thought about your work as a defender from wherever you are. And so you're doing your work knowing that if anything bad happens, there is a fund that I can apply to. So that psychological support, if I may call it, I think that is very important.
You've got different situations where either the defender needs to leave a particular area, for safety reasons, and that needs to happen now. There are times where defenders are often imprisoned, and they need lawyers and quick responses. And that was a big thing for us, to be able to provide support for this as well. Natural justice capacity can't, we can't respond to everything. So the idea is to work with other lawyers as well and ensure there are funds to support their efforts as much as possible.
The Sangwer people have remained steadfast in the pursuit of their land and human rights over time. They remain hopeful that the government will do right by the community.
Hata serikali wakifanya nini hatutachoka. Hata wakimaliza sisi wenye tuko, wengine watakuja na watafuata tu hiyo mtindo. Tumeamua kwa kauli moja ya kwamba tusiwache ardhi yetu ya babu na kwenda kuishi ya wengine tukue watumwa.
In parts of Tanzania, forceful evictions have become an unnecessary evil. The evictions come with intimidation, threats, and arrests.
Kwa hiyo kama tunataka Ngorongoro ibakie na inauza Tanzania, tuwe serious maintain na kuhakikisha Ngorongoro inabaki kwenye status yake. Kuhamisha watu sijui mtafanyaje.
This is a story of suppression.
Hakuna askari aliyekwenda huko kijijini kwenda kutishia kwa namna yote ile, kwa sababu kwenye mipango yote hakuna kijiji kinaondolewa, hakuna mwananchi anaondoka, hakuna tatizo lolote la mifugo.
The Serengeti National Park in Tanzania is a haven of untouched beauty, drawing thousands of admirers every year to witness the grand wildebeest migration. But behind the stunning scenery lies a hidden story. The park's success has caught the eye of the government, eager to expand its reach within this protected area. In the village of Loliondo, the government has announced plans to carve out a piece of the community's land for a hunting lodge.
They want to evict us from that land because of 3 reasons. One is because of it is a disposal area for wildlife. Second, it is a migratory route for wildlife. Thirdly, it is where source of water which feed Serengeti National Park come from. But to us, that is not enough reason.
In 1992, the Tanzanian government leased community land to a company from the United Arab Emirates whose intention was to convert community land in Loliondo to a game lodge for trophy hunting, greenwashed under the premise of conservation efforts.
We had in a continuous conflict since 92 up to now. We had a continuous conflict about that land because the land is ours as villagers. We have titles and the land is ours in general. Since we were moved from Serengeti by colonial government to Loliondo, and we were promised by the colonial government that we will continue to use that land without any conflict or anybody to intervene or interrupt us again.
On 7th June 2022, a paramilitary group estimated to be around 700 people, mostly police, park rangers, military and other security forces, arrived in the Loliondo area of Ngorongoro, Tanzania. Amateur footage recorded by one of the residents shows how violent the crackdown was, including the shooting and arresting of those protesting against the installation of beacons to hive off part of their village and make it hunting grounds.
I am an innocent person, and even our people are innocent, but we have been harassed because of it is like a surprise to us.
Now, long-time leaders have been forced to flee as a result of their opposition to the forced evictions.
Traditional leaders, community, political leaders faced a lot of intimidation. Others are taken to jail. For instance, we have 24 people now in jail. They are charged with murder case, which is still going on. So there's a lot of intimidation that has been going on. And actually, they were also attacking civil society organization, the NGO, and the individual, like myself and the others.
Edward Porokwa has been an environmental defender since his years at the University of Dar es Salaam in Tanzania.
On a specific case of Ngorongoro, I've been involved for almost 20 years now, trying to support the community to raise their voice, linking them with media, linking them with international mechanisms, trying to develop different positions and analysis of the rights of the people to land and natural resources.
After years advocating for communal land rights in Tanzania, he too has found himself a refugee because of the Loliondo land matter.
Like now, I've been out of my community. I've been away from my family for more than 2 months, worrying that I will be joined in a very serious criminal case which I have not committed. I have not even been there when it was committed, but you are worried that the government is doing all the means to silence the people.
On the 9th of June 2022, more than 10 Maasai leaders were arrested and more than 30 men and women were wounded during violent clashes.
So you can find now people being charged with murder case that took place when they were at the hand of the police.
If you don't speak, if you don't talk, the violation will continue to happen. So we will have to continue talking, continue raising our voices to different level, not just out of the country, but even the country. Want to see how do we change the attitude of the people, the policymakers.
On September 21st, 2017, the Maasai community had lodged a case at the East African Court of Justice seeking a declaration that the Tanzanian government had broken the law. However, on September 30th, 2022, the Maasai people were disappointed as the regional court ruled in favor of the Tanzanian government and declared the decision to reserve land for wildlife preservation as lawful.
Whichever side of the coin you look at it, I think in itself that is not the end of the fight. I think the biggest challenge we have, and something we are strongly advocating for, and I think something that we need to continue talking and pushing, is having national legislation, having policies at national level that recognize and protect land and environmental defenders.
The defenders of Loliondo have not given up on a peaceful resolution of the matter.
My government is an elected government, and it was elected by the people of Tanzania, including the people of Loliondo, including the people of my ward, that to have mercy to people. Because if people suffer because of their government, the government they have elected, it will be really very bad. So I humbly ask the government to listen people, to listen as the leaders of the people. And finally, we can have a concrete solution on this problem.
Local community they know their rights. And once you know your rights, you never stop until you see you bring the change that you want.
Thousands of kilometers away is the island nation of Madagascar, famed for its unique biodiversity, abundant natural resources, pristine beaches, and unblemished vanilla. In contrast, danger is never far away from the defenders and their families. 70-year-old Henry Rakotoa Arizoa, a community leader and a champion for the protection of an endangered rainforest in Madagascar, is one face among other land and environmental defenders. Henry dedicated his life to the protection of Madagascar's forest as a community leader and lately as the president of the locally based community association Mialo, which protects the Ankazondandi forest outside of Moramanga city. On multiple occasions, he confronted and reported on illegal loggers in this area. On the 2nd of June 2022, protecting the forest cost Henry his life. He was killed inside the forest he has been trying to protect from illegal logging by traffickers for several years.
Ny antony amin'ony fombafomba amin'ony anazy zany a, nifatorandry zareo tady izy. De rehefa nifatorandry zareo tady izy a, niala teo leo amikesika aloha izy a. Zay aloha nita vavolombelona, fa azoko lazaina any le izy. De niala teo leo amikesika izy. De nandeha moa zany izy nakeny leo amikesika e. De nanafatra le hoe filopokon'olona le hoe Ndriny zay ny anarany. De izy moa mampiara-miasa zany de nampitondra any ivelany ary manatona aminazy a, de fanatona foana izy manoro-hevitra olona foana marina. De natsolo le hoe Randriny izy eo mikesika hoe misy zavatra alakevitra aminao rangaha fa amekara ozy izy ety amikesika. De niakatra dadanay moa tsy poe tsy malala ninnininy zany.
As the son continues to grieve for his father, a wife's sorrow refuses to go away, lingering on, reminding her every day of the loss brought about by Henry's death.
Gina aloha tsy mba hitako tenenina mihitsy fa hita tena banga mihitsy ny antokatranoko mianak'izay za miray trano sisa telo mianak'izay miray trano tao de iny izy lasa de mianaka zanako fara lasa za sisa fa ny ankizy zao mbo any amin'ny tokatrano daholo de ty zany zanako lama toe fa ny amin'ny tokatrano koa io fa io zany mbo ampiaraka amina mandehandeha fa tena hitako hoe banga mihitsy ny tokatranony menaka.
In Madagascar, standing for the truth may expose the defenders to harms with irreversible consequences.
Tsy mety satria izy zany olona manompo famarinana zany. Zany azy zavatra tena tsy andefera mihitsy zany ary amin'ny fiarovana an'io aly io a. tena nena zany raha misy mety ataon'ny olona de tena tebany mihitsy de tsy mahazaka ny tenen'ny io le olona hoe izy zany mameva olana an'le olona alohany tsy avoale olona fa le olona zany misesika ihany manaonao foana.
The threat of death has, however, not kept environmental defenders in Madagascar away from their calling. Edmond Koto knows the importance of mangroves for his village and his environment over life. He knows the protection that the mangrove offers against the harsh waves of the sea. Unfortunately for him, one day in December of 2021, the mangroves were also the location of a near-death experience for him.
Tenene, nchabu tenene, nchabu tenene, nande tanya mdeze talata na murzana kungu. Talata. Nande tanya, afanave mdeze ru ampanafiki zingi navito. Linda almisi, changana mdimilairu nande na nafiki tami amiala faadito. Antotolene. Arafanave zingi ruzi, chitane ru picha mzana kungu abitu. Arafanave tu zazing in fifirendum dezing, ni lefer nama kufazafu zing in narata tuzing, zingam dera na manguzito ma fatchamalunito, untotolienata.
Ganaro ni ano rovo ni ne fundi nambora azaga naro, inora di naro tiu. Roka fanangan karai za fanchanga na zinakorom sabua, tura kanali, maru karaza famaki, amtangando. Roka fanangano karaha za fantsanga zany impody boka direct inga zandranako amindray roka fanavy ro boka tare inga zandranako tafepiky amindray boka izy niala zay sisika ankotoka zanak'ongo to.
Edmond was rushed to hospital after a significant loss of blood. It was a miracle that he survived.
Rantafiandroza to donc alandroza zimi mkulukulu ra toltoliena io. Ary zay zegny tsy amin'ny fikokoloagna izy zay miezaka fo zegny amin'ny fikokoloagna tontolo iainana.
The African Environmental Defenders Fund, an emergency fund that is given to defenders who have faced threats and harassment due to their work as environmental defenders, has gone a long way to help him recover.
Le hoe raha aminaka fo tsy asitriko ny vandy hoe le sakafo zegny jaliako. Zanako zegny mianatra mandeha l'école, zanako aroy. Sakafo amindray zegny tegna jaliako agnatin'izegny amindray voatery ka ireo mitsikoroky amin'ny fagnampiagna amin'ny fitahagna ry agnamezandreo ilika za amizio.
Defenders in Madagascar go through different challenges in their work.
Those people who protect the biodiversity, the forest, they are exposed to abuses from different parts of those people who have connection with the authorities, with traffickers, with everything.
It is not just the mangroves that environmental defenders are protecting in Madagascar. Even their village and territory of life is at risk.
Amba Victoro agnarako. Zaho teraka tao Zamanjary Osibe.
In 2016, a government directive was issued and required Victor and his neighbors to vacate their village. This was meant to pave way for a private investor who had secured a 50-year lease for the land.
Kanefa ni misy procédure manko alohan'ny mahazo bail zegny. Tsy tanay nagnano reconnaissance, tsy tanay ny affichage, tsisy fampiovagna fa tonga de votraka fa nahazo bail avy 50 ans pour 17 hectares. Or kanefa ny toerana ipitrahan'olo, misy fokon'olo mipetraka, misy fokon'olo miegna amin'le toerana.
For the period that the village has existed, Victor says the villagers have done all they can to keep the environment safe.
Ary tegna mampalahelo koa fa le toerana 17 hectares io faritry Pointe de tortue. Io misy le tortue de mer miakatra magnantody. Matoa hatramizay tortue tsy mela io magnantody zay fokon'olo tsy magnelingeligny tortue fa iarovanay zegny tortue magnantody foiny antodiny mivery mandeha an-dranomasy.
They have faced death. They have been beaten and threatened. But the defenders in this island nation are not giving up anytime soon.
Dina mbola trabo zao zany io fiarovana ny tontolo iainana io zany dia mampalahelo anazy zany raha hoe zavatra niarin'ny dadanay zany hoe atao tsintsinina zany ny resaka fampitehana ny tontolo iainana satria izy tena olona mibanjina zany fiarovana zany izy dia amin'ny mahalamatoa anazy zany dia vonona tanteraka any koa zany anaraka masony zavatra tsy mety satria io zavatra tsy mety io zany dia efa hita hoe fambana resaka io nge tsy hoe ho anana ho andranona ihany fa era zao tontolo zao potika rehefa hoe misy zavatra simba ray e.
Every day, African environmental defenders face death, beatings, threats and harassment from their governments.
The importance of partnerships in this context is that it ensures that we reach a wider scope of defenders, especially those defenders whose voices are often not heard and who often never have access to these kinds of resources.
We are able to support defenders who are playing this incredible role, not just for their communities, I would say for the continent and the globe.
For many of them, protecting the environment means putting their lives on the line. It means staring death and harassment in the face and emerging victorious.
Let's now talk about the tunnel warfare underway in the Gaza Strip. The battle has gone underground into the notorious tunnels built by Hamas. The Israeli forces have reached deep into Gaza in order to crush the militant group Hamas. They are on the hunt, using explosives to destroy this vast tunnel network. The tunnels stretch for hundreds of kilometers beneath Gaza, presenting a unique challenge to the Israeli forces, a challenge that will make the already difficult urban warfare a lot more complex. So what do we know about these tunnels and what challenge do they pose? Let's first understand that this is the next phase in the Israeli offensive. Its ground forces are trying to locate and disable the Hamas tunnels. They say that they have entered the heart of Gaza City, the largest town in the Palestinian enclave and Hamas's main stronghold. According to the chief Israeli military spokesperson, Rear Admiral Daniel Hagari, Israel's Combat Engineering Corps are using explosive devices to destroy the tunnel network. The Israelis believing that the hostages are held up here and they fear that their military operations could endanger these hostages. In fact, the Israeli defense minister has called Gaza the biggest terror base ever built by man.
Gaza is the biggest terrorist base ever built by man. The entire city is one big terror base. There are kilometers of tunnels underground. They connect to hospitals, to schools. They are connected to each other.
Good afternoon. Good afternoon. Honorable judges, you will forgive us. We have turned our backs on court, but we still uphold the rule of law. Thank you for the quick deliberations and getting back. And we would like to start our award ceremony. And we will start. So if I call out your name, please come forward and receive your certificate and or your medal. We don't know. So we'll start with the best, we'll start with the research paper. Okay, there we go. We'll start with awards for the research paper. Second runners-up for the research paper, Wanjiko Ngatia. Is she here? Is Wanjiko Ngatia in the room? Does she have a proxy? All right. The first runners-up for research paper, Tony Blair. Is that a proxy or are you Tony Blair? Thank you. And finally, the person who gave the best research paper, William Kanani.
All right, this is the fun part of the 3 days. And one of the things I forgot to do was I forgot to introduce everybody who's here. You met Dean Lando earlier on Thursday. Farida is the Executive Director of Natural Justice who was able to join us today. And my apologies for not introducing her earlier, but we're really glad you could come today, Farida. Research presentations is the next category. Second runner-up, we have co-authors, so you might know who you are already, Kaiser John and David Lakula as the second runners-up. Watch out, watch out. And the first runners-up is someone who will be coming up again, Wanjiko Ngatia. Yes, so did we proxy her already? This is first runners-up, Wanjiko Ngatia. No. She was also second runners-up for the paper. So someone has your certificate somewhere. Make sure you get it. It wasn't issued? Oh, okay. So make sure you come for it, Wanjiko. And the winner for Best Researcher, William Kanani.
William, if I were you, it's a lot of bling, eh? If I were you, William, I would live here with co-author of my papers for publishing in a renowned journal. We will now award for the memorials. So the second runners-up for the best memorial, second runners-up, Moy University, Team 220. Are we in the room? Do we have Team 220, Moy University? Thank you. Make sure to follow up for your certificates later. First runners-up for the best memorial, Team JKU Art, Team 216. Thank you. And finally, for Best Memorial, we have the team from University of Nairobi, Team 226.
All right, the next category is Best Oralist. The best male oralist is Ryan Kamunda. Ryan, you're from Riara. Congratulations, host team. And the best female oralist is Christine Ayombe. So at this moment, we've finished with yesterday's category, and we will now pass it over to our 5-bench panel and to our presiding judge, Judge Waboto, to take us on to today's competition. We'll get some feedback from the bench, and then we shall find out who the winners are today. Over to you, bench. Thank you, Judge.
Good afternoon once again. League judges, we'll begin the final session of the day. We will start with receiving comments, general comments from my colleague judges, and then after that I'll proceed to render the decision of the court, and then of course we'll also conclude by pronouncing the winning team, and also according to the judges, the best counsel from the submissions that were made. So at this point in time, I wish to invite Justice Kimani just to give you general comments and reflections on the particular session that we had. Welcome, Judge.
Thank you very much, Presiding Judge. It was a great pleasure to listen to each and every one of you, both counsel for the petitioners and counsel for the respondent. The quality that we witnessed was indeed final quality, right? And you ought to be proud of yourselves for all that you have achieved. And 2 days that you've been here, congratulations. They were excellently thought out. You had ingenious solutions to very nuanced problems, and even though you had to get protection from the presiding judge, you withstood the heat of the moment. So you ought to be proud of yourself, as stated earlier. And I'll give just 2 comments to just better improve your submissions, considering we believe that this will not be the end of the road for you, but you will further advance the cause of environmental protection, even in international competitions and all that, and even maybe as litigating counsel in the future. So first, it's important to listen to the judge. Listen, if a question is being put to you, I know there is the anxiety of wanting to finish up your submissions or even just answer the question and then get back to your submissions. But as I like to tell participants, the moment you are asked a question, that becomes the most important part of your submission, not whatever it is that you intend to submit. Answer, listen to the question. If you do not get it, ask the judge to pardon the question, understand it, then proffer an answer, rather than having a predetermined notion on how you're going to proffer the answer without even listening to the question in the first place. And secondly, pace yourself. We understand it's you're filled with butterflies, it's an anxious exercise, but you ought to pace yourself so that we are able to hear you, understand you, and so that we are also able to engage you. But if you just even presiding judge at some point was like, what did you say? Because we could not hear. And because we also have the vision for your very bright future, you will find people who English is not their first language, right? So they will need to speak a little bit slower, so that you also incorporate a certain element of passion, in your case. But if you're just speaking in a very fast manner, it's almost impossible for us to feel the emotion in your case, and for us even to judge the tonal variation and all these other aspects of the presentation. But overall, well done. I hope to see you soon, maybe even as members of the bench. Thank you.
Thank you. I'll share 2 comments and 1 encouragement. So on the comments, a bit of it, the presentations were good, and congratulations to everyone for taking part in this competition. To the final teams, whenever you get a moot question, always try to do deep research over and beyond the issues raised. If an issue is on an environmental impact assessment, research generally about that area of law. You have sufficient time, read widely, because when the questions come, you will never be aware where they come from. So as the judges, when we are listening to your responses and you are trying to fight back to your arguments, yet that question had nothing to do with what you had predetermined to submit, and then a little bit we think that you haven't done wide and deep research. So work on deep research, in-depth research. And then secondly, on the presentation style, try and work on your presentation style. Be conversational, is what I was telling you yesterday. You are submitting to us. It's that simple. Just have that in mind. You need to be conversational so that you are not reading a script from your eyes. I could see some of you would say it has been submitted by the second counsel, ABCD. Yet clearly we have heard the other council didn't say that. So it clearly shows that you had a script. So don't read from a script. Finally is the encouragement to each and every person who participated here. Take this activity as a very important activity. 2 reasons why. Last week I met a new friend. I'm forgetting his name. Jessica knows him. The friend from the World Bank. What is his name? It's called Dr. Tomkin. Dr. Tomkin was sharing his testimony. He is a doctor, PhD. He works for the World Bank. He used to work for the UN. He went to Moot, the ICJ Moot at the UN complex, and his team lost. After his team lost, he didn't feel happy, but he stayed around, so he was just hanging around, talking to people. And that is how he got his way into the United Nations and now the World Bank. When he was hanging around after he had lost, he met someone who works for the UN. And he was telling this person about the Moot question, about how he has lost, about the issues, about the research. And then this person said, we can exchange contacts. Before he realized, when he was finishing school, later on he ended up working for the UN. Now he works for the World Bank. So when you're in this Moot competition, definitely only one team will win. But for you that has not won, always ask yourself, what are you getting from this competition? Are you talking to people here? We have a learned judge from the Environment and Land Court. We have Dr. Owino from the Kenya School of Law. We have the legendary Kimani. So we have Elias here. So you have to talk to people, get these networks, because that is the essence of bringing all of us here together. And finally, and for those ones who did the research, I encourage you to go and develop those research papers further and consider publishing them. Personal experience, I participated in the All Kenyan Moot Court competition research category. My research paper was not the best. I didn't win. I thought I had done a good research paper, but there were others who did better than me. So I went and asked my lecturer, it's called Walter Kobe, what could I do? Walter Kobe told me, review here and here, and then send to the platform for Law, Justice and Society for publication. I sent. Gitobe Manyara, the chief editor, told me, this is an amazing paper, you can be a good writer. That was the beginning of my writing journey. And I ended up winning the CB Madan Award. So what am I telling you? Oh, thank you. You are 4 years late, but I appreciate. So I want to end it on that note and to encourage each of us. It's a great initiative. When you go to apply for opportunities, don't say that I participated in the Natural Justice Moot Court competition. It discussed issues of climate change. It discussed issues of EIA, and this is how it impacted me. When you put that in your application, we know that indeed you took value from this competition, and nobody will deny you an opportunity. All the best, and may God bless you.
Thank you very much for such a wonderful morning, participants, oralists in this Moot Court. It really has been great listening to you. You came dressed for success, dressed to impress. You have really submitted your arguments, well thought out arguments, demonstrating your breadth of knowledge of not just the facts of your case, but also your knowledge of the law. So I congratulate all of you for that. I would just urge you to note that your case is not won on the day of making your submissions. Your case is won, at least 80% of it, by the preparation that you make and your knowledge of the law at the international, regional, and national level. So going forwards, always aim to make sure that your substance is really high. In life, you will be judged by the content of your the substance of what you say, right? And many times you will meet people who really know, and you cannot say a provision or quote a provision that doesn't exist. You cannot say something when there's something else that really fits the situation better. And the only way you know that is because it's on your fingertips. So I used to do this with my friends when we were passing each other on the corridors, fingertips. You have the stuff on your fingertips, okay? So going forwards, I wish you very well. Also note that this is not the end, this is the beginning. You're going on to compete at a global stage. When I was in university, I competed in the JESAP Moot Court competition in 2005, which I'm now revealing my age, but that was in 2005, and I'll never forget the year. It was transformational for me. We represented Kenya in Washington, D.C., and what stood out for me was the fact that you're Kenyan, but you're a human being and a member of the global community. So don't limit your thoughts, your legal arguments, your knowledge to Kenya. At a global stage, we were competing with Australia, the UK, Canada. We got to the quarterfinals. We were beaten eventually. But what stood out for me was the quality of argumentation from those other universities, the way they presented themselves, yet we were more or less age mates, told me this game is, there are levels. I know you people say there are levels to this thing. There are levels, and always make sure that you're setting yourself to operate at those levels, those international levels, and then bring it back home and improve our country. I wish you very well. It was nice listening to you.
Yeah, I would like to convey my congratulations to the Mooters. I think as a teacher and a practitioner, I saw a very high level of engagement. And I would really want to say that whereas mooting might not look like a serious business, at times it becomes that opportunity to start identifying what you will settle for in the long run. And I got this invitation at fairly short notice, but I can assure you, had it been on international humanitarian law, possibly I would not have been here. But when I saw the topic, it was irresistible, because this is my day-to-day passion: climate justice, questions of now carbon trading. And I really said I have to go and hear what the students have to say. Because at times you think we have it all, but I think, is it Chief Justice Madan who says a judge is a judge, and I would transfer that to a lawyer is a lawyer. I might have the benefit of experience, whereas you have the benefit of your most recent learning, and perhaps you even have more time than myself to research. So I cannot belittle your knowledge, because you might, in a very phenomenal way, come across information that is quite critical in a way that I might not. And so mine is to inspire you. Keep going. You're already on a very good trajectory, and I wish you the very best wherever your career takes you. Thank you.
Once again, thank you to my colleague judges. Let me begin by appreciating for the opportunity and the invitation that was extended to me. I've attended a moot court session before, but on a different topic. But for issues of environmental justice and climate change issues, this was the first ever that I had to attend. And on that, I'm extremely grateful to have had an opportunity to join you and to participate on this. And also equally, when I received the invitation through our chief registrar, I quickly accepted the opportunity to come and learn and share with you. So on general comments, I also wish to thank each and every one of you who was able to attend and participate. Having attended this moot court finalist, I have I'll say fairly grateful to have interacted and learned from you. And I must say, from the topic that was chosen and presented, I was extremely happy and encouraged by the presentations that was made. I must congratulate you for that. Secondly, I should add that, of course, Moot Court is normally an avenue for young lawyers or students to try and have a real-time opportunity or run-through on what they'll experience in future. So it prepares you for your future career progression and, of course, the real life in practice. And my advice to you is that always pick up the lessons that you learn and the interactions that you engage from this, and also the aspects of preparation that you go through. So for this particular day and the session that we have, I will keep encouraging you that when you are presenting your cases to court, of course, even considering the others who had been here earlier, as you had been told, my colleague, of course, at the court stage, it is like the final tail end for you to convince the court or the judge that you have a case. So always ensure that you submit persuasively to be able to convince the court. For those who are able to follow the proceedings of the BBI, which were much, or rather the election petition, which was highly publicized and televised, you'll notice that there's normally a difference between the senior counsels and the new counsel in terms of persuasiveness and how they submit. This is simply because when you are before the court, you're actually submitting and putting forward your case, especially on issues that are a bit gray and lie on a borderline. They have not been finally settled. So it's an opportunity for you to submit and convince the court. So you're normally expected to have that in mind. And also ultimately, they'll also tell you it's also important to understand the psychology of that particular court and its jurisprudential that it relies on. So it's very important to make a focus on that. In terms of encouragement, of course, I'll keep on encouraging you. Don't shy away. For those who turned up and took the challenge, keep participating in more opportunities and challenges. And of course, you'll continue to learn more and interact more on that. So once again, thank you so much. And also, once again, I also appreciate for the opportunity that you extended to me to be able to attend and participate in this particular session. So I think with those few remarks, you'll allow me to move to the decision of the bench. Yeah. So for the petition that was presented by the two teams here, that is the petitioner's case and the respondent's case, the bench, upon considering the parties' submissions, going through the evidence that was presented, and the issues that were outlined for consideration, the bench arrived at a conclusion that the respondent's team or the respondent's counsel were able to convince and persuade this particular bench that indeed the petition the petitioner did not meet the threshold to warrant the grant of the reliefs that they had sought. So in view of that particular position, we proceeded to dismiss the petition. Also, the court was also able to observe that in as much as the respondents were able to convince the bench that the petition did not meet the threshold in terms of their presentation and the case that was put forward, we would have awarded the respondents the costs of the petition, but considering the fact that the respondents' counsel kept the court waiting for a period of 30 minutes or so, the court declines to grant them the costs of the petition. So that is the decision of the court. It is so ordered. Thank you. Yeah, so we, in overall conclusion, as per the bench of the judges who are present, the best performing team in the finalists was team 226 of the respondents. And then on the second category of the judges award, that was what we considered from the today's finalists, the best performing council. I will leave that to be announced by my colleague Judge Justice Wambua. Welcome, Justice Wambua.
For the judges award, we were impressed by all the submissions, but there's one person or oralist who was calm under pressure, who maintained their poise, who articulated their argument quite convincingly, and this is Lindsay Asiome.
Again, thank you so much. In so far as the jurisdiction that was vested in this particular court, I think as the presiding judge, I wish to announce that the proceedings of this court stands adjourned, and that marks the end of our court session. Thank you.
Thank you very much, Presiding Judge. I would like to invite you to come forward to be able to present the awards to today's winners, and including, I believe we also have an award for the research presentation as well. Yeah. So maybe we start with our second runners-up. First runners-up. Absolutely, yeah. Yeah. Are we certificate? Yes. Please come forward. Which law school, which university are you with? Kenyatta University, wonderful. So here we go. Thank you very much. And now we will invite our winners of today's Moot to University of Nairobi. Perhaps, Lindsay, you might just want to pass on the trophy and come right back. To Lindsay, for today's best oralist, please welcome back. Congratulations to you on a job well done. All right, so the exciting thing, of course, is that we have trophies. You notice them coming in just in time. So we would like to invite the folks who were just the first, right? The first two? Salome? All three? So this is everybody who got awards today. So if I may please start with my justice on my far left, Justice Kimani, to come and help us present some of these awards. These are to the best research paper. We had Wanjiko Gatia as the second runners-up. Tony Blair. First runners-up, Tony Blair and William Kanani for best research paper. Please come here and receive. your trophies. Well done. Congratulations. A trophy? You can give them both. This is first that was the best? Okay. Wanjiku Gatia? Yes? All right. Second runners up. And is Tony Blair here for first runners up? All right. Dale, can you bring the other two as well for first? Second runners up is Wanjiku Gatia. And let's just bring the first. Yeah? Let's bring it up. Congratulations. Thank you, Justice. Justice Talia. For the research presentations, please all come up at the same time. Second runners-up, Kaiser John and David Lekula. First runners-up, Wanjiku Gatia, please come back. And best researcher, William Kanani, please come back. Second runners-up. Second runners-up. Wanjiku, no. Second runners-up, here. That's first runners up. First runners up here. Wanjiku Gatia, first runners up. And best researcher, William Kanani. William, please step here. Thank you. William Kanani, best researcher. Congratulations. Thank you, Justice Tully. Justice Clarice Wambua, please. You will be presenting the best memorials. Second runners-up, 220 Moy University. First runners-up, 216 JKUAT. Best memorial, 226 University of Nairobi. Please come up and get your trophies. Moi University, second runners up. Congratulations. Thank you, Justice Wambua. Can you please come up, Justice Owino? This is now for the final trophies for the, sorry, we have 3 more trophies. Huh? Best oralist, yes? Yes. So best male oralist, Ryan Kamunda. And the best female oralist, Christine Ayombe. Congratulations, both. we have one more award. This is to the second runners-up in the Moot Court competition, Team 220. Team 226. It says it can't be, but that's right. It's Moy University. So I'm sorry, I have your number wrong. So Moy University, please come and get your certificate overall for being second runners-up for the Moot Court competition. Moy University. Congratulations. So with that, we come to the end of our second Environmental Justice Moot Court. I want to just say a very, very, very brief thank you, the deepest thank yous really, to all of you who came here. I will begin with the participants from 15 law schools. I think we were nearly 90 students who registered to participate. We wouldn't, of course, be having this moot court if you didn't come and show up. And show up you did, and worked really, really hard all leading up to the 3 days. So thank you all for joining us in this journey as we're trying to develop this new jurisprudence of environmental justice law. We, of course, thank our judges, both those who are still in the audience, who have been with us for the last 3 days, and particularly our five-judge bench today. With all of you, thank you so much. Presiding judge, we appreciate the time you've given us, and really appreciate also from those of you who are here, the wisdom you have given to the students. To our partners, CMR, thank you. What a great adventure we're going to be going on. This is our first year partnering, really looking forward to working together very closely. To Riara Law School and Riara University, who have hosted us again. Like we said last year, hope we'll see you again next year, and we deepen this partnership, really appreciate it. And to all the students who volunteered from Riara, clearly we couldn't have done this without you. The ushers and the bailiffs and the people running around doing all kind of admin and logistical work behind the scenes and in front of the scenes, to all of you. And then, of course, to the natural justice team. You can probably tell that there have been many sleepless nights. You've seen messages from them coming at all hours. A brilliant moot question that they've developed. They've worked with all the participants, all the judges. I want to say really to the team that's here and the team that isn't here today, our and my deepest gratitude for putting together such an excellent moot court. You get to rest for one evening because you know we're back at work tomorrow. And so thank you again. We look forward to seeing you all in some capacity, either here participating or behind the bench as judges in the next moot panel. Thank you, everybody. Be well, get home safe, and have a great rest of the weekend.